Screen check. Screen check.
Good morning. Today's June 25th, 2024, and the current time is 9 o'clock a.m. Welcome to Day 2 of the evidentiary hearing in the staff of the Missouri Public Service Commission versus Leon Travis Blevins, also known as Travis Blevins and Patricia Blevins, doing business as Misty Mountain Public Water Supply, also known as Misty Waterworks, Charity Public Water Supply, and Rolling Hills Public Water Supply. My name is John Clark. I'm the regulatory law judge presiding over Day 2 of this hearing today. As I indicated yesterday, commissioners will drop in and out through the day, some in person, some online. We have commissioners already participating or listening online. When we left off yesterday, we had just concluded with witness Dalton Young, and staff still had a couple more witnesses to go. So is there anything that I need to take up before staff calls its next witness?
We'll have copies of Exhibit 10 that you'd asked.
From yesterday?
Yes.
Thank you. Thank you. And these have already been admitted onto the hearing record, so I do not need to address them further at this time.
I don't think there's anything else.
And staff, you may call your next witness.
I'll call Kurt Gately. What is this? What do I have?
Mr. Gately, would you come down and raise your right hand to be sworn? Do you solemnly swear that the testimony you're about to give at this evidentiary hearing is the truth?
Yes.
Please be seated. Go ahead, staff.
All right, thank you. Good morning. Would you please state your name and spell it for the record?
Curtis Gately, CurtisGateley.
And by whom are you employed and what's your position?
Staff of the Public Service Commission. I am a regulatory compliance manager over the Water, Sewer, and Steam Department.
And just generally, what are your job duties and responsibilities?
I supervise a team of engineers, analysts, and auditors. We process applications for water, sewer, steam companies before the Public Service Commission, and we also investigate customer complaints.
Excuse me, and do you supervise Adam Stamp?
I do.
And is he one of your inspectors?
Yes.
And just generally, what are his duties and responsibilities as an inspector or an analyst?
Adam's primary responsibility is conducting inspections or field investigations for cases that we're dealing with. He also conducts routine inspections of regulated companies.
And are you familiar with Leon Travis Blevins?
I am.
And you familiar with this case?
Yes.
And how did you become familiar with that?
I believe I initially started receiving communications from DNR in December of 2022, or around that time. They were concerned that Mr. Blevins was operating a utility company without a certificate from the Public Service Commission.
And so what's been your involvement in this case?
Initially, I was leading the investigation. I believe at that point Adam was a relatively new employee, but he was shadowing me from the beginning and me showing him how I would pursue the investigation. As time went on, Adam has taken the lead on it.
Okay. And excuse me, have you met with Mr. Blevins at all during your part of the investigation?
Yes.
And can you tell me about that? What you talked about? What was discussed?
In the spring of 2023, prior to us filing any of our cases, myself, Adam, and one other staff member met with Mr. Blevins at one of his offices to discuss what we had found, what we believed that he was operating a utility without a certificate, what the PSC rules were, that sort of thing. Discussed it with him. But it became clear to us that we had to formally file cases pretty rapidly and try to address the situation, given the lack of safe and adequate service to the customers there, and the fact that it was pretty obvious that they were being charged for service.
And did you explain what the PSC rules are and why he might be subject to regulation?
Yes.
And can you tell me what you told him about? Did you tell him anything specific about it?
Well,
them?
I mean, it was an initial meeting, so, I mean, we did speak in more general terms, but that any entity that charged for service that operated as a utility, unless you were a not-for-profit entity, was subject to Public Service Commission rules, that he'd be subject to things like an audit and establishing rates. There were rules on customer service, that sort of thing.
And did he seem to understand what the discussion was about?
Yes. I'm like many people who don't know that we exist, there was initial confusion of why are you even here? But yes, he understood to the point of through our conversation, but he also knew that there was going to be additional discussions and details past that. I believe we only spoke for perhaps an hour, which isn't enough time to cover everything.
And did you have any other discussions with him or any other involvement with Mr. Blevins? Like other than this first meeting?
That was the only meeting that we had just one-on-one with Mr. Blevins about the general situation. I was present for other hearings here with Mr. Blevins and with a public information session that we had with customers, but that was the only time when I was just talking and explaining with Mr. Blevins.
Okay, and so pretty much, did Adam Stamp, Mr. Stamp, do the rest of the investigation? Or how did it go from you to
It was
Mr.
fluid.
Stamp?
As he gained experience and understanding of our processes and my expectations, he took more and more of the lead. But as far as dealing with the customer complaints themselves and the one-on-one situations with the customers, he led most of that himself.
Okay, so he'd be the one to testify to most of that?
Yes.
Okay. Now, you said DNR initially contacted you or the PSC about Mr. Blevins' systems. Do you remember, you said that was December-ish of 22?
I believe the initial communications were around December of 2022. We started receiving customer complaints, I believe, in January of 2023.
And what did they want the PSC to do?
We have a working relationship with DNR where if they suspect that there's an entity that may need to be regulated by the Public Service Commission, they're going to give referrals to us on those. And we give them information as well when we see DNR violations, of course. But at that moment, I mean, besides the wells that are subject to PSC regulation that they're too small for DNR to regulate, they had concerns about some of his wells, and one in particular where he was refusing to install disinfection.
And do you remember which well that was?
I'm sorry, they blend together.
Okay,
I've tried.
That's fine. Now, obviously, we don't regulate this. The PSC doesn't regulate the same types of things that DNR does. So, how is that regulation different? Can you explain that?
From my perspective, when the PSC is evaluating whether someone's providing safe and adequate service for water, those standards of safety are set by the DNR. If you're complying with, for drinking water, if you're complying with their rules on safety, like maintaining adequate pressure within the lines to prevent contamination and meeting the requirements to not have pathogens in the water, other contaminants, those sorts of things, that's the safety portion. And obviously, we are charged by statute to enforce safety rules, but DNR sets those rules, so we work with them as far as those kinds of evaluations.
And so DNR has certain wells that, or well systems that they regulate. What about the other wells that Mr. Blevins might own or might operate? Does
There
he
are
have,
some number of wells, we aren't certain exactly how many, because he wasn't recording them with the county initially, that are too small to be regulated by DNR. They need at least, I believe 25 persons or 15 connections to be big enough to be regulated by DNR. And because many of these wells were constructed by developers trying to evade DNR regulation, then you have lots of them that are built that have fewer connections than that. For example, the wells on Rowden Lane, the well on Rejoice Lane. There are others. I don't know exactly how many, because we haven't been able to use records to figure out how many he's providing service from, because he's not got them all recorded with the county as his ownership.
and so what actions did your section end up wanting to take once you began looking into and investigating the complaints from the consumers?
It was clear that he was, to staff, that he was operating without a certificate. But the more we learned about the way that Mr. Blevins was operating his companies, the way that he was not responding to problems, the billing complaints we were receiving, his lack of infrastructure that other companies have, it became pretty clear to me that he wouldn't be capable of complying with PSC rules. As he wasn't complying with DNR rules, he really wouldn't have much chance of being a successful company. I've seen the PSC issue certificates to companies that we then had to turn around and file for receivership because they weren't willing or weren't capable of complying. I felt like the most appropriate step would be to move for receivership as soon as possible.
Okay. So so the complaint and the receivership, now he filed an application for a CCN, is that right?
That's correct.
And that was case number WA 2023-0418. Do you know what became of that?
Staff filed a recommendation to not grant a certificate in August of that year, and then Mr. Blevins withdrew his application in on October 4th, I believe, of that year.
Okay. And what was staff's recommendation in that CCN case?
To not grant a CCN.
And what was staff's reasons for denying or wanting to recommending denial of a CCN?
Do you want me to speak generally, or do you
Generally,
want to go through because
generally,
he lacks or appears to lack the technical ability to successfully provide safe and adequate service. He lacks the infrastructure to comply with Chapter 13 rules on customer service. He does not appear to or have the financial wherewithal to operate the company, or he is simply choosing not to properly operate the company because he wasn't fixing the problems that need to be fixed. We heard testimony yesterday about customers having to thaw out wells every year in the wintertime. That's not acceptable. If we had one of our other small companies, a regulated company that started letting the infrastructure fall apart and not provide safe and adequate service, we would be filing complaints or filing for receivership, depending on how severe the situation was. There was nothing to suggest that Mr. Blevins would be able to provide safe and adequate service.
Okay. And that recommendation was filed in the receivership case? Or not in the receivership case, the CCN case?
In the
I'm
CCN
sorry.
case, the WA case, yes.
The WA 2023-0418. I'd ask that the commission take notice of this recommendation that was filed in WA 2023-0418. I can move that be admitted as evidence or as an exhibit.
No, that's
but
the
it's
one.
already been filed.
That is the one that is attached to the list of issues, correct?
Yes, it's also attached to the list of issues, yes.
Mr. Blevins, have you seen staff's recommendation from the CCN case, the 418 case?
No, sir.
Do you have that to show to him?
I do.
Mr. Blevins, would you skim that real quick and let me know if you have any objections to admitting that onto the hearing record? It's staff's recommendation that the commission not grant you a CCN or certificate of convenience and necessity.
Is this the recent one?
When we filed the CCN case.
No.
Now, you've indicated that you wanted to withdraw your CCN application, but this is still staff's recommendation from that file, and they're asking that it be admitted as evidence here by having the commission take official notice of it.
But to my recollection, it's the first time I've seen this, but I have no objection. But I don't, the CCN, I can't meet those requirements. It's not a utility company.
Now, you just said something that had evidentiary value, and I'm going to remind you today that you're still under oath. You understand that?
Yes, I understand I'm under oath. This is the first time that I've seen this document where staff recommended not to issue a CCN.
Okay. Do you want to take a moment and I can go off the record and you can read it? Or do you want to
Well,
stand?
maybe I should read it here, I guess.
Let's go off the record for a moment. Mr. Blevins, do you have any objections to the commission taking official notice of staff's recommendation in WA 2023-0418?
If that recommendation is not to issue a CCN, I have no objection to that. I was not seeking a CCN, or I was withdrawing my application for that. I do object to a lot of the verbiage and that's on these documents here, but I don't see any reason why I would object to not making it part of whatever we're doing here.
Okay. Well, if you have problems with the verbiage that you'd like to address during your testimony, I'll certainly allow you to do so, but
Okay.
in regard to the objection to the verbiage, I'm going to overrule that objection, and I am going to take official notice of staff's recommendation in WA 2023-0418.
Thank you. And just for the record, that staff recommendation was filed in that case on August 15th of 2023.
And there's an accompanying memorandum, correct?
Yes,
That is also part of the recommendation.
yes, the staff recommendation and the memorandum, yes.
Thank you. Go on.
And other than the CCN case, the receivership case, you said filed that. That's already gone to hearing.
Correct.
That was WO 2024-0037.
Yes.
Okay. Or 36, I'm sorry,
Yeah.
0036.
Sorry.
And that action was filed in August of '23. Do you remember?
I don't recall that date. I could look it up, but
Okay. It'd be in the filing and it'd be needless, right?
yes.
Okay. I would ask, or move that the commission take official notice of the petition for interim receiver and for an order directing the general counsel to petition the Circuit Court of Cole County for the appointment of a receiver for Misty Waterworks and motion for expedited treatment that was filed in WO 2024-0036. I believe that was filed August 15th, 2023.
Mr. Blevins, do you have any objections to the commission taking official notice of the petition for a receiver filed by the commission staff in WO 2024-0036? That's the petition for the case that we had the last hearing that you were here on in this room.
Do I object to the petition? No, sir. I have no objection to it.
Okay, the commission will take official notice of the petition of staff's petition for a receiver in WO 2024-0036.
Thank you. And we had a hearing in that action on October 25th and 26th of '23. Do you remember that?
Yes, sounds right.
And you testified at that hearing?
I did.
And you were cross-examined by Mr. Blevins?
I was.
And you presented evidence, your attorney entered evidence during your testimony during that hearing?
Yes.
I move that Mr. Gately's testimony in case number WO 2024-0036 be entered into evidence as exhibit, I think we're on 12? Exhibit 12. Specifically, Mr. Gately's testimony is found on page 7 to 48 of volume 3 of the transcript.
Do you have that as an exhibit?
Yes.
Okay. Do you want to distribute it?
Okay, this too.
And I believe this is exhibit 12?
That's what I'm handing in right now. Oh, yeah. Okay.
Thank you.
And other than those cases and the complaint, did staff ever think about filing any other type of action, immediate action, with regard to Mr. Blevins?
Yes.
business? And can you tell me about, or can you tell the commission what staff was wanting to do,
There were
thinking about doing?
there were internal discussions of filing for an emergency injunction, given that customers were being charged for service by a company that appeared to be, subject to PSC regulation, but those customers were, or a portion of those customers at least, were receiving contaminated water. There was no boil advisory, and there was no apparent movement to correct the problem. In other situations, there were extended outages where, again, customers were being charged for service, but were not receiving any service. There were several situations where staff considered it pretty urgent. Those discussions happened, but ultimately an injunction was not filed for.
And what was the harm or potential harm that staff was specifically concerned about? Anything else besides what you just testified?
Well, I mean, the expectation would be if you don't have service, then you have unsanitary conditions in your home pretty rapidly, and folks aren't able to flush their toilet or wash their hands. But folks receiving contaminated water, I mean, E. coli is an indicator bacteria. It's pathogenic, but it's also an indicator that there's probably other pathogens in the water. Giardia, Cryptosporidium, the things that are harder to test for. We had significant concerns that folks may get sick.
Okay. And there's been testimony about public hearing that was held last June of 2023. What was your role in that?
The public information session?
Yes.
Is that what you're referring to? I had organized it and scheduled it with Jackie Johnson with DNR to obtain further information from customers. Mr. Blevins cooperated to an extent by providing us with most of his customers' addresses. We later learned that customers of at least one well system were omitted for whatever reason. But we had quite a few folks show up, a lot of scared folks, a lot of angry folks who we wanted to obtain information from them about their experiences, but obviously having Jackie and I in the room, they were asking us questions as well and trying to understand the regulatory roles of the agencies.
And so what seemed to be, were there main concerns that the homeowners had, or was it just general concerns? Can you explain that?
I would characterize the primary concerns as fear that their water wasn't safe, refusal to honor the contracts that they had signed for a water rate, and oftentimes a lack of responsiveness by Mr. Blevins when something went wrong, either leaks or lack of service or whatever the issue was. There are folks who were perfectly happy with their water quality, but who were angry that they had their rate changed when they felt they had a contract for a certain rate. There were customers who were suspicious of the entire situation, but didn't have specific concerns. But there were dozens of people who approached me and Jackie with situations that they were pretty angry about.
And Mr. Stamp was there as well?
He was in attendance, yes.
And did Mr. Blevins seem to have concerns about what was being discussed or what was going on during that meeting?
I didn't engage directly with Mr. Blevins at that meeting. He was in attendance. I believe other customers had specific discussions with him, but the goal of the meeting was to hear from the customers. So I wasn't separately meeting with Mr. Blevins, and he wasn't trying to step in. We were letting people talk.
Okay, all right. And so the attendees at the meeting, some of them were served by the 3 public water systems that DNR regulates?
Yes.
And then were there others that were served by some other wells?
Yes.
Can you explain what, so there were wells that were regulated by DNR, and he was also operating wells that are not regulated by DNR?
Correct.
Okay. And if PSC takes action, would all of the wells, how would the wells be affected, or would they be affected?
All of the wells that he is acting as a water corporation where he's charging for service would be considered together as part of his effort at doing business as one of these companies. They would all be subject to regulation, including compliance with safety standards, testing, having a certified operator. Those sorts of requirements are minimum expectations that we would have, regardless of whether individually they were too small to be regulated by DNR.
And now, yesterday, there was a witness, Mr. Grube, and other witnesses testified about outages occurring, and that it sometimes took Mr. Blevins a couple days or even longer to get the water back running for the homeowners. Can you discuss what impact that might have on those homeowners who don't have running water for a few days?
I mean, the obvious, not being able to wash your hands or cook food or flush your toilet, take a shower, but you also have to consider that there are people who would have young children in the house and more than just taking care of themselves. I mean, some of those folks may have had to go stay with relatives or go stay in a hotel. Depending on your stage of life and how you're used to living, you may be able to be pretty flexible for a day without water. But I know that I received customer complaints that were more than a day. It was days without water at certain times. Now these were what customers told me. These weren't moments where I was out doing investigations, but those would have a significant impact on most folks, and they're paying for service that they're not getting.
And so does, if Mr. Blevins was providing like bottled water, would that cover, do you think that's sufficient when there's outages for multiple days?
When a company knows they're going to have outages for several days, we work with them to ensure that they're generally minimum distributing bottled water. But the standard for most companies is they haul water in. There's been several examples that I've dealt with where lightning hit a well, or there was some catastrophic failure of a piece of equipment where companies had to haul in water tanks to where they could provide water for folks. It's not a lot different than what we see in disaster responses for people, just on a smaller scale.
And did Mr. Blevins do any of that remediation?
Customers said that there wasn't anything like that. I was not present to verify that it didn't happen.
Okay. And what does that say, if anything, about Mr. Blevins' ability to run a water utility?
To me, it's whether it's a lack of will or a lack of financial ability, it demonstrates that he's not able to meet the kind of standards that we would expect from other small companies. I'm aware of a company of about the same size that had their well fail and it couldn't be fixed. The well pump was seized up. They had to punch a new well. So they had, I believe it was about 2 weeks. They arranged for a local milk hauler to clean, disinfect his tank, and haul water to keep their water storage full so that people would have water. That's the kind of response that's necessary when you know you have a major problem that can be fixed, or it's going to take a while to be fixed. And being able to do that is part of running a utility company. Water is critical for health and safety of your customers.
And do you think Mr. Blevins would be able to do that with the information that you have?
I do not.
And so, all right, so now let's talk about the complaint that was filed in this case. There were two counts. There was one was the unauthorized operation of a public utility, And then the second count was protection of the public health and failure to provide safe and adequate service. So looking at count one, can you explain what it means to be operating as an authorized or an unauthorized water utility for the PSC purposes?
As a non-lawyer speaking, if you don't have a certificate, you don't have authorization.
And based on the information that the staff has received, Mr. Stamp during his investigation, is Mr. Blevins operating a water utility?
In staff's opinion, yes.
And what is it that he's doing that's considered unauthorized water utility?
He's providing water service to the public. He's charging for that service. He's operating a business, a four-gain company to provide water, and doing it without authorization from the commission, without oversight of rates, oversight of safety, et cetera.
And there's been some talk about what it means to sell or supply water for gain. Does the company need to be making a profit, need to be making a gain? What does that mean?
Does a company need to actually show a profit to be operating for gain? Is that your
Right.
question? No, absolutely not. Just like any other business, a company can fail to make a profit through the way they operate that business or what may occur to that business during the course of a year. A not-for-profit company or other entity is, a legal entity that exists and is set up appropriately to be able to demonstrate that they're not for profit. Simply deciding on some rates that you estimate might make you a profit, as Mr. Blevins has said that he did yesterday, certainly to me shows that he's operating a company for gain, whether he actually turned a profit or not.
And do you know if he's filed any kind of non-for-profit status for Misty Waters, any of his companies?
I've been told that he has formed HOAs to try to operate 3 of the water systems.
But with regard to Misty Mountain or Misty Water Works or
Oh,
any of his other
no.
companies, has he filed anything?
No, we have no record. The Secretary of State's office has no record of any of those businesses actually existing.
So he hasn't filed anything with the Secretary of State's office, whether it was a non-profit status or as a business entity?
Not associated with what the customers had showed us, the companies that they were being billed by, like, gosh, I can't remember something Corral was one of the companies, and him operating himself. No, we haven't seen any kind of filings for those. Outlaw Corral, I'm sorry.
Outlaw
Yeah,
Corral.
I just remembered.
And now with regard to count 2 of the complaint, and you might have already touched on some of this, but can you explain why the PSC is concerned with protecting the public health and providing safe and adequate service? I mean, isn't that,
Well, that's part of the statutes that empowers the PSC. 393.130.1 discusses safe and adequate service. DNR, I heard some interesting opinions and testimony yesterday. DNR has a process where they deal with entities that are violating their rules, and they provide quite a bit of assistance. And some of us might hold an opinion that they provide maybe too much assistance, but they have a process. Whether someone likes the way the message is received or not, the facts are that Mr. Blevins is not complying with their minimum safety standards. He's left a well that broke, hasn't capped it. Despite some of the testimony that was said yesterday, it isn't a situation where someone can remove a cap and it provide a source of contamination for the aquifer. The rules exist on plugging wells to keep water from getting down, keep that from being a straw down in the aquifer, and right now it is broken at the top. That's how we learned that contamination was getting into the well. That has the potential to cause bacterial contamination of his other wells and other wells nearby. That sort of thing cannot be ignored. He knew he was sending water to customers containing pathogens and didn't do anything to change it for months and months until that well broke apart on its own. Those sorts of things I find alarming. Never mind the other less emergent situations where folks don't have service. But we exist, the PSC exists to regulate monopoly utilities so that folks aren't at the mercy of things like random bill changes. And some folks having their bills nearly double when they're not receiving, in their opinion, adequate service is also a significant concern of ours. But the safety issues will always be first.
And those are issues and concerns that are different than DNR's concerns or what they can regulate. Is that right?
To a degree, yes. We regulate, ours is primarily the economic regulation of it. But whenever we have a situation where it's a safety problem like this, for the companies that are subject to PSC regulation, we're both interested.
Okay. And what about adequate service, service in an adequate manner? Is that, can you explain what PSC's, and you might have already kind of touched on this, but can you explain what PSC's role is? Is that different than DNR's role?
DNR does not have a lot of rules associated with adequacy. Even their minimum water pressure, which we would, as customers, consider an adequacy issue, from their perspective is a safety issue to prevent contaminants from, keep a drinking water system pressurized, keep contaminants from coming in to the pipes. Beyond that, they have very little that I would consider adequacy issues. PSC staff are making sure that there's adequate water if storage is necessary, depending on the way the well is built, that the well is big enough to serve the number of customers connected to it, that if a company has a certificated area, they're planning for growth and expanding their systems as necessary. Those are not regulated by DNR, and simple outages are not regulated by DNR. DNR would regulate if a boil advisory was necessary due to low pressure, but a well being turned off is not, doesn't necessarily require a boil advisory.
What about customer service issues and customer complaint issues? How?
Those are, to the best of my knowledge, only handled by PSC unless a customer is complaining about a safety standard.
Okay. So if they weren't, so if it wasn't regulated by the PS or by DNR or the PSC, there wouldn't be anybody there.
Correct.
And your testimony, there should be somebody there?
Absolutely.
Now, since staff filed the complaint and the receivership cases, has staff been doing anything to find a receiver or someone who could, or an entity that could buy or take over Mr. Blevins' well systems?
Staff has reached out to a few. There wasn't anyone who expressed interest beyond their initial investigation of the situation.
Do you know if there are any companies out there that might be willing to take over the system?
I believe there are.
And can you, without naming names or giving any confidential information, can you kind of give the commission some information about what kind of company that would be? That you've been...
I have discussed the situation with one company. Has told me that yes, they would be interested in purchasing the system. There's another company that I believe would be willing to step in and purchase it. They're companies that have demonstrated the ability to do this work.
Are they companies that have worked with small systems?
Yes.
And do you think that would be beneficial? Do you think that those are avenues that might be able to be used?
I think that's the only way that we can help these people. I think that a company with the financial wherewithal to step in and take corrective action, fix problems, punch another well if necessary. DNR have expressed to me that some of these wells really weren't sized appropriately for the number of customers that they have. It's typical for DNR to recommend disinfection in areas with karst topography. Certainly in Pulaski County, there are plenty of wells that have become contaminated through no fault of the owner of the well, just the groundwater is contaminated. It's Swiss cheese, so you have a lot of surface water that gets down really deep and can contaminate aquifers. That would probably be one of the first steps that a more responsible utility would take. They would also establish easements where the distribution system is, make sure that there were appropriate valves and such to where they could turn off service to a section of pipe to make sure they could fix that without everybody being out of service. There's a lot of initial steps that a more responsible company could take, including eventually probably installation of meters so that folks would have a bill based on usage and receive a monthly bill, have somebody they can get a hold of as an emergency contact, bring in their operators and backup operators so that there was always somebody able to run the system. Those sorts of immediate actions would be necessary, and I think only one of the companies that has demonstrated that ability could step into this situation. The county has expressed to us that their public water supply district, they are not interested at this time in stepping in. There isn't a municipal system that's right close by that could annex them. So short of some other not-for-profit entity deciding they wanted to start operating in Pulaski County, I think that one of the companies I spoke about would be the best solution.
And so does the PSC regulate other small waters similar to the Blevins system then?
Yes.
And do those small water or sewer companies have varying levels of modernization, sophistication?
Yes.
With regard to their record keeping, some of those companies have varying levels of record keeping, whether it's by paper or on computer.
I know of one company
product.
that still keeps their records on paper. I know of one company that still does all their calculations of their bills on paper. Their records are meticulous. That person just simply chooses to do it on paper. The other companies I'm familiar with have all moved on to a computer, and even at a basic level of keeping track of the customers and meter readings and such, customer complaint logs, things are required by Chapter 13.
And when you and Mr. Stamp were investigating Mr. Blevins' systems, his record keeping, compared to those other small utilities that the PSC regulates, what was the comparison?
Given that he's not yet regulated, there was not a full audit of the records that he was maintaining. While I was there with Mr. Blevins at that initial meeting, some customers were present, customers who were paying bills or discussing how many more months they had left. He had a ledger where he was keeping track of that. But I did not see any evidence of extensive record keeping.
Okay. And so when staff has these small water and sewer companies, do you work with them kind of where they are to, a little differently than you would with, say, a larger company?
Certainly, there's quite a bit of assistance that we provide. There's a big difference between a company with 100 customers and a company with 100,000 customers with an army of staff to run things. Mostly what we do, though, is just advice. We're discussing with them frequency of rate case filings, making sure that they're keeping record of even the small expenses that they have so that they can become reimbursed. The sorts of things that we watch out for to make sure that a company stays healthy financially.
Sorry. And so as a result of your, the staff's investigation and findings that ended up culminating in this filing of this complaint, what is it that you're asking Mr. What is it that you're asking the commission to do?
We believe that obtaining a receiver, a court-appointed receiver, and getting this company sold to a utility company that can operate the systems as quickly as possible is the right thing to do for the customers.
Now, the complaint didn't talk about receivership. So in the complaint, what, are there certain things you're asking the commissioner to do?
You're starting to get into the realm of the lawyer knowledge. I don't know that
I mean, are you asking for
any
penalties?
action in particular would have to be done with this complaint, but we can, yes, we can seek penalties associated with him operating an illicit company.
Okay. And can you explain why the staff will be seeking penalties at this point? If you can.
Anytime you have folks who are, there has to be a deterrent. Anytime you have a situation where someone could be choosing to try to evade regulation and evade the costs associated with regulation while other folks are following the rules, that's what the penalties are there for, as a deterrent to keep people from deciding that they can try to skirt the rules for as long as possible. I don't know for certain that Mr. Blevins started off doing this on purpose, but it was explained to him early on that he wasn't allowed to charge for this kind of service and run a company like this without a certificate from the PSC, and nothing has changed.
Okay. Do you have any questions? I don't have any other questions. Thank you.
Mr. Blevins, do you have any questions for this witness?
I do.
Go ahead.
In your testimony, you got a lot of negatives in there. My question would be, what do you do with these negative complaints or whatever you call them? What do you do with them?
Are you speaking about customer complaints or the things we observe?
Customer complaints to start with.
Typically, when we receive a customer complaint, depending on how much information they provided initially, we may be reaching out to them for further information. And then with our regulated companies, the next step is to reach out to that company and say, okay, what's your side of the story? A lot of times these complaints are about perhaps a dispute over a meter reading, or another common one is when water lines are repaired and they don't like the way their driveway restored, those sorts of things. Then we're usually going out, and a person like Adam would go out and visit this site themselves to be able to lay eyes on it. We will then respond to a customer as to whether or not there was a violation of the tariff rules or any law violations. The customer can then decide whether or not they want to have a formal complaint where they have an opportunity to be heard before the commission.
Well, specifically, customer complaint in this particular case against me, I guess, or Mr. Blevins, who happens to be me. What do you do with that complaint? A specific one. Do you know of one?
We have several informal complaints. We have several complaints that have come in just by phone calls and emails. Because a tariff isn't in place, we don't have a certificate issued to you to authorizing you to operate your company. There's not a tariff violation to cite or a penalty to be sought or a remedy necessarily to be sought with complying with a tariff rule because you haven't had a tariff issued to you yet. We received complaints that some customers were without water because one of the wells had been shut off by the power company because the bill wasn't paid. There wasn't a remedy for us to seek in that immediately. What the customers then told us was they called the power company and got the power company to turn it back on just as out of the goodness of their hearts. Those sorts of things, there isn't necessarily a penalty pursued by us for that. It's in this situation, we believe that a change in status of your company is the way to resolve these problems.
Well, specifically with that one that you said that was off because of a non-payment, how long was
What
it off?
customers told me. I personally I did not speak to the power company.
Okay, then who did? Do you know who did?
The customer stated that they did.
What particular location was this at?
I don't have it specifically. Adam probably knows the name of the well.
Yeah, you don't know how long it was off or anything?
No.
Or what the circumstances were involved
No.
with it?
No, I know it's unacceptable. I know I don't have any other companies we regulate that fail to pay power bills, but I don't know anything.
How did you determine it's unacceptable?
Why?
Yeah, well, how did you determine it's unacceptable?
If there's a company that subject to PSC regulation, their costs are built into rates. And all the costs associated with running that company are collected from the customers. It would be unacceptable in my eyes, and I think in most reasonable people's minds, for a company to take that money and then not pay the electric bill to keep the well running.
Did anyone ever contact me, Mr. Blevins? Did anyone contact Mr. Blevins about a power outage of some sort?
I don't know if the customer separately attempted to contact you or not.
You don't know?
I do not.
No, okay. What did you mean by no service? That I did not provide a service?
Some of the customer complaints we received were for outages.
But yet there was no investigation, or it was just a rumor, or what was it?
Well, we had a customer here testify under oath about their outages and how they resolved them. We had several other customers who have complained of various situations. We had some that we investigated ourselves where we were out there. We have others where we have DNR investigatory reports that describe the situations.
Yeah, well, the one that you are referencing from yesterday's was something about a heating unit in a well or something?
A lack thereof, yes, a customer having to go provide the heat themselves.
Yeah, do you believe that? Did you investigate that?
I have no reason to disbelieve it.
Do you have a reason to believe everything that they say? Without investigation and draw conclusions?
I have a responsibility to respond to complaints from customers.
How did you respond?
I am not attempting to prove the veracity or seek penalties for a problem that happened in 2019, because that's not the solution we're asking for right now. What we're asking for right now is, in a separate case, a receivership, in this case, operation of a company without authorization from the PSC.
This authorization, in the fact that these wells have been in operation for 15 plus years, what happened to their permit to issue water and charge in the last 15 years? How do you deal with that? How did you determine that now it's another problem? It's a problem, but it wasn't in the past.
I would argue that if the same facts existed in the past, that it was also a problem then.
Well, did it exist in the past? Were these wells in operation?
That's what I have been told, yes, that they have been in operation for a while. I don't know when each one was drilled.
Well, did they have a permit
I
to
don't
be
know.
in operation?
I have been told by DNR that they were not
Okay.
properly permitted.
Okay, not properly permitted. What is the process that gets a permit?
While I did work for DNR for 14 years, I worked with wastewater, so I don't have as much familiarity with their permitting process for getting authorization to construct a well for a public water supply. I don't know. I believe that most wells are, regardless of how many customers are on them, are required to be registered with U.S. Geological Survey. But I don't know what the permitting process was when these were initially drilled. I know through my experience with wastewater that sometimes the regulations and requirements change over time.
I imagine they probably do. You mentioned technical ability, indicating that I had no technical ability. How did you determine that?
I did not determine that you had no technical ability.
What did you determine then when you say
I would describe
technical
it as,
ability?
I would describe it as not adequate. A company, or not necessarily a company, any entity, if something isn't corrected, then it's either a lack of ability or a lack of will. That lack of ability can be a lack of financial ability or a lack of knowledge. I don't know why things weren't fixed.
Well,
I don't
in
know
general,
why, but
what
it's
things
demonstrating
were
a
not
lack of
fixed?
Mr. Blevins, please
Yes.
stop interrupting your witness when they're answering your questions.
Pardon?
Please stop interrupting your witness when they're answering your question.
Okay, I apologize for interrupting.
I'm sorry, what was your next question?
Well, we were talking about technical ability. You indicated that my ability is not adequate. My question is, how did you determine that?
Preponderance of evidence would be my best explanation.
Do you have the evidence? I'm sorry, I didn't mean to.
Starting with either an inability or refusal to provide disinfection when the evidence was presented to you that you were sending water containing pathogens to customers. The lack of boil advisories. The lack of boil advisories due to low pressure events. The failure to repair well houses so that they were maintained in such a way to keep the water and the water supply safe. Those in and of themselves demonstrate a lack of ability or a lack of will.
It appears in a general explanation didn't really apply. Did you apply that to a specific problem with Mr. Blevins or myself? What were those
I mean,
problems?
I described several, but if I've been doing this a long time, the one situation, one incident that was short and was resolved quickly does not demonstrate a lack of will or lack of technical ability. Something that's allowed to go on for a long time, like the problem with the contaminated water, when solutions are available, that is a specific situation that alarmed me and made us consider things like going to court for injunctions to try to get a judge to force a fix on the problem.
Do you think that the problem is not being addressed even today, tomorrow, or whatever? It's not been addressed in the past?
I believe that based on the behavior that's been demonstrated over the last 2 years, that there are current problems. There are things that haven't been addressed, like the well that hasn't been plugged. And I believe that there will be future problems that are not addressed with appropriate urgency.
Okay, well, I don't think we're getting where it really. You indicated that I had done things to evade some sort of rule or whatever. What did you mean there? How did you determine that?
Based on my experience in DNR and through enforcement activities and my knowledge of other wells that were and subdivisions that were put in Pulaski County, the original developers were intentionally not putting in a centralized distribution system so that they were not subject to DNR regulation. And those sorts of situations where someone punched multiple wells with fewer customers to try to evade DNR is what led to the case saying that if you have a common development plan like that, you can't evade these regulations. They're designed to protect people, and with DNR's drinking water rules and the federal rules that they come from, the regulations are built on how many people are put at risk. And the idea of trying to punch multiple wells and avoid DNR regulation, I have seen through my experience that was done intentionally to try to avoid that. I am not alleging that the person who purchased the wells later was involved in such an effort.
How did you really determine then, basically, that that was an activity to evade something? Was there some other evidence to show you that?
Like I said, I wasn't involved in the enforcement case against, or any enforcement case against these folks who have punched these wells that you purchased from. I was involved with other cases where DNR was going after people who were doing the exact same thing in the exact same area, which I don't have paperwork to show it to remind me exactly, but I believe that some of the same builders were involved. But this was many years ago.
You mentioned something about that something was refused to be installed in these wells. What were you referring to at that time in your testimony?
I believe I was referring to when DNR demanded that disinfection be installed because of the contaminated well water that was being delivered. Perhaps that was the Topo well?
The Topo. Yeah. So you think that all of these other problems that existed or was created into a negative situation, and currently the same negative situation exists with these wells?
The information that Adam has found and the complaints we've had from customers and from DNR are that there are currently ongoing problems. And from what I've seen, I would expect to see further ongoing problems.
Do you see any corrective actions being taken?
In some situations, after a lot of pressure and complaints and DNR contacts and those sorts of things, yes.
What kind of pressure and complaints are you speaking of?
Customers who have told us that they had to call you multiple times, DNR having to send letters, DNR having to call you. And in some situations, folks tell us that they're going to the media and they're going to their elected officials. Those kinds of things are what people are trying to resort to. DNR is, they have to stick to their process. And based on what I heard yesterday, now they're having the Attorney General's office try to step in and compel you to comply.
Did you determine that they've already done that, or?
Yesterday I was told that they're going to do it tomorrow.
I see, yeah. Well, I don't think I have any more questions for you, sir. Thank you.
I'll note for the record that the chair of the commission, Kayla Hahn, has joined us in person in the hearing room. Are there any commission questions for this witness?
Yes.
Go ahead, Chair.
Thank you, Judge. Good morning, Mr. Gately.
Good morning.
I am just going to go through a series of things that you touched on just because I want to verify some things that are not totally clear in my head. Yesterday, Mr. Blevins, for the first time, said that he had registered nonprofits at the Secretary of State's office that would, in effect, by doing so, potentially alleviate the fact that he may need a CCN to operate these systems. I want to make sure I understand you. To your knowledge, there is no record of any filings for nonprofits to operate these systems at the Secretary of State. Is that right?
There are no filings associated with the businesses that he previously represented. I do not know, I did not try to independently verify that he had filed for these, I believe it's 3 new homeowner associations. I believe that Adam Stamp has tried to verify that.
Okay, so I will ask him.
I
Okay.
heard testimony yesterday that there aren't members, that no one has joined those, but I don't know for certain their status or if they were properly filed.
Okay, thank you. Also, for clarification, yesterday, the witness that testified, the customer was part of one of the HOAs that were formed. So, for the record, because I get very confused between all these systems and wells, I think the one from the customer yesterday, there's 9 customers as part of that well in that HOA. So how many customers? I heard also yesterday there's about 60 customers. So I'm assuming about 51 customers are left at issue, or are there more or less? Can you just give me
We believe there are approximately 100 customers.
Okay.
The HOA that customer was referring to was a well that Mr. Blevins never owned, but was charging people to be served by their own well. They formed a different HOA, which would be a 4th one, separate from his 3rd.
Okay.
3.
So what systems, if he was charging folks for systems that, or well, he didn't own, do you, and you don't have to go through them for me, but do you all have an understanding of what systems are still at issue and which wells are still at issue now, taking that one well aside? I know it's a tricky question.
We have a difficult time saying that we absolutely know every one of the wells that he is putting himself out as owning and operating. We know of some additional ones. For example, the one on Rejoice Street or Rejoice Lane. Those, I believe, is 7 customers on that one. I've been to that one. Extremely vulnerable socioeconomic situation. I believe Adam said that within the last 2 months, Mr. Blevins had gotten his deed properly filed for the ownership of that well. So previously, that one didn't show up in the county records. But we knew from customers that that was one that he was billing for service. In our complaint, we have a list of some. The ones on Rowden Lane are not part of the HOAs, for example. There's a handful of others, but Adam would be better to speak to them.
Okay. Also, I think Ms. Kerr's line of questioning got at this, but speaking about options moving forward, you had mentioned that you had spoken to developers or a company that's interested in purchasing these systems. If the commission were to put this in receivership, then the company could purchase the systems? Or
Yes.
how does, okay.
Yes, the receiver would be charged with that disposal, yes.
What if there's not a receiver? Or how, walk me through this process.
Without the commission appointing an interim receiver and then a court endorsing or appointing a different receiver, then I don't think there is a legal method for that sale and the money from that sale going to creditors and to the owner of the property at this time.
Okay, so currently the commission could put the systems in receivership, but we haven't been able to identify a receiver.
We have not been able to identify one who is interested through our own informal efforts, no. I've not been a part of one where we would do it without something that we had prearranged. I mean, the law exists without that. It's just more convenient if we know someone who already has some kind of knowledge of water systems in this case, who'd be willing to be the interim receiver. But there are receivers who are appointed by courts routinely to dispose of the assets of a defunct company.
Okay, so a court could appoint a receiver and then a company could be eligible to purchase it at that point.
Certainly.
Okay.
In such a situation, we would have to be prepared to answer additional questions and assist that receiver through the process.
Okay. Earlier you'd mentioned, and I'm really curious about this, there were some fairly significant issues with service. And you had mentioned that there was a potential thought that there may be an injunction filed to either require, I think at the point was to have Mr. Blevins stop cutting off people's service for various reasons. Tell me why. I don't believe there's a staff filing on, saying to recommending the commission to take that action. Talk me through why.
An injunction, it wasn't my idea. There has to be some kind of method, though, for dealing with a company that operates as a water corporation but simply refuses to acknowledge PSC existence, and an emergency situation occurs. There has to be some legal avenue, and it's my understanding that an injunction would be an opportunity if we go to court and have a judge order him to take whatever the action is that's necessary to get folks to having safe service again, that could be taken, and if you refused, you could be in contempt of court. Those options exist. It was discussed internally, and it's my understanding that for some situations, Mr. Blevins eventually got it resolved before we overcame our own internal inertia, and for some other situations, it was discussed and decided it wasn't necessary.
Thank you. Also, earlier in your testimony, we were kind of talked about the goal of this complaint case would be to appoint a receiver or to also seek penalties. If the commission were to recommend putting the system in receivership, talk me through how often have staff also then assess penalties as a deterrent if the system is already in a receivership? What's kind of standard practice, if you will, in these types of cases?
Standard practice is that a company either has gone bankrupt or someone throws the keys at us and says they don't want to do it anymore. That becomes a voluntary receivership, which means that we aren't seeking penalties. So this, for me personally, is new ground. Someone who's a little more mature, a little older might have some idea of that if he had experienced it previously, but I haven't been down this road before. And the decision to seek penalties would not be mine alone.
Thank you. Earlier, between you and Mr. Blevins, I can't remember who said it, but basically the summation was that corrective actions in some cases have been taken to remedy some of these wells. But it's my understanding, the general summation of your testimony is that they're just not being taken timely. Is that a fair statement?
To a degree.
Okay.
That well that provides a contamination source down to the aquifer still hasn't been plugged, despite months. And then there's also the DNR violations that haven't been resolved. Other situations, I believe that there are probably some situations that where actions were taken quickly, but there are an awful lot of them where we keep getting complaints about that they weren't taken care of for quite a while, sometimes until after folks had to complain to a government agency and the government agency had to get involved.
Okay, so not timely or just not at all?
Correct.
Okay, thank you. No more, I don't have any further questions. Thank you, Judge.
Are there any other commission questions?
No, Judge.
I hear none. I've got a few questions for you, Mr. Gately. I'm kind of trying to understand a little bit more the genesis of this complaint. So my understanding is that in December of 22, DNR contacted the commission staff. Is that correct?
Around that time, yes.
And what was the nature of that contact? I mean, what did they relay?
That they were dealing with a non-compliance situation where they felt it was someone who was probably subject to PSC regulation.
Were they expressing that as a safety concern, or were they expressing that as this person should be regulated because they're selling water?
Both.
And when did staff start its investigation?
Immediately. We did let DNR know that if they got further customer complaints that we would like to receive those, and that opened the floodgate to customers reaching out to us, some filing informal complaints. Well, that was my request that they do so we would have documentation, and others who just wanted to call us or send emails. But it was shortly thereafter we had a meeting with DNR, me and some members of my staff, and then we started gathering facts for preparing for these filings. But then we also, in that spring, at some point, I don't remember the date, went and met with Mr. Blevins.
Thank you. That clarifies that for me. What has staff done to establish what it is Mr. Blevins owns?
We have sent him discovery requests. We asked for his records demonstrating what he believes he owns. We've also spoken with the county. Initially, Pulaski County has their records online where you can view ownership and parcels, and we could see where the county clearly indicated that for some of the wells that Mr. Blevins was charging for service, he didn't own according to the county records. I believe we also did record searches with the county to try to look for what he had. I did not personally review the records that Mr. Blevins provided himself. I believe the attorney did and Adam may have. But some of the wells, it appeared pretty clear to us that there was no record of his ownership of that property.
And I think that's probably true. I remember from the previous receivership hearing and also from I remember from his previous hearing that he indicated a lot of these were, quote, handshake deals or just, so I understand he may not have owned some of these wells, but it appears that he believed that he owned some of these wells that he may not have. Is that your understanding as well?
I believe that's fair, yes.
Now, he had originally, and he'd expressed when he was up here before that he applied for a CCN, largely because you indicated to him that that would be the proper process to go through.
That's my understanding, yes.
At that time, did you believe he'd be able to successfully complete that process?
During the initial meeting, I didn't know. I hadn't formed a solid opinion at that point, but I had explained what the legal process for a company to become regulated by the PSC was, in general terms. And more than once during that, I recommended that he hire an attorney, that it's a legal process and that he would benefit from that advice because I couldn't get into specific details on how he would file such an application.
Now, you had indicated that there was contaminated water being served to customers for months and nothing was being done. Is that correct?
Correct.
Were you referring to the Topa well?
I believe that's the one, yes.
And he at some point did get a system operator, Lori Jean. Is that correct?
Correct.
Do you know how many months into the process before he got a system operator?
I don't recall.
Had he tried to do anything in regard to dealing with contamination at that well?
The records I had on that were from DNR, and no, that they didn't have anything to indicate that he had taken action.
Okay, were you here for Lori Jean's testimony yesterday?
Most of it, yes.
Were you here when she indicated that she and Mr. Blevins both struggled to try and get that contamination under control?
It was an interesting statement.
How so? Explain it to me.
We learned that the well was broken at the top, at the casing, but the first thing you do when you have bacterial contamination is you install disinfection. You don't assume that there's some catastrophic failure in the ground. That's not typical. It's extremely unusual. The proper thing to have done would have been to apply for a construction permit with DNR and install disinfection equipment and everything that was necessary to do that. I don't know of a situation where you properly, quote, struggle to deal with bacterial contamination. DNR allows folks to try to what's called shock a well by putting chlorine down it. Sometimes that's a temporary fix. In karst settings, DNR recommends disinfection anyway for groundwater systems. But in this situation where you had a broken casing where surface water was getting in at the top, putting chlorine down it wasn't going to do a thing. But it's not what I would consider a reasonable response in a karst area to repeat bacterial contamination samples. It's install disinfection and protect your customers.
Is that something that his system operator should have pointed out to him?
System operators are not engineers. They're not charged with finding the most prudent and cheapest and most sustainable option. That operator should have recommended disinfection just like DNR was doing in their communications to Mr. Blevins, but there's more than one way to do it, and a responsible business owner, the next step is to employ an engineer who can look at the best fit for that situation.
And I hate to opine here, but I'm going to a little bit. You had indicated that one of the reasons that staff requests penalties is as a deterrent. Now, staff isn't out looking for water systems to regulate. That's not what you spend your time doing, correct?
Correct.
you generally only do that when these systems somehow come into view through a complaint, a DNR referral, something like that.
Yes, the vast majority are customer complaints.
And so I guess I'm curious as to, and this is where I'm going to opine a little. It seems like at the PSC we see a lot of these where developers come in and they either build a water system that is DNR compliant or build one, as you said, that is dispersed to avoid DNR regulation, which I don't know DNR regulation well enough to know if that's illegal or if that's just clever business practice. But then those developers leave. And they go on to build whatever else they're going to build elsewhere, and they kind of leave these systems. And then either residents or whoever's taken over the system are left with these incredibly expensive systems to repair and fix, and they end up getting a large bill down the road when that happens. What I'm getting at is, I don't know how effective is a deterrent against small operators like Mr. Blevins, who wasn't even aware of the PSC until you showed up on his door.
There are those who, I'm going to be expressing my personal opinion. The decision to actually pursue penalties is not mine alone. There are those who are informed that we exist and that they need to file paperwork and they need to properly either properly operate a water corporation with a CCN or change their business practice to some degree, whatever's necessary. Some form not-for-profits, some are in a situation where maybe they stop charging for water. If an entity chooses to continue doing what they're doing despite having been informed of the law, then I personally think that penalties may be more appropriate. But it wouldn't make any sense for staff to file a complaint like this, knowing it's a protracted process generally, without also seeking that authorization for penalties. That I think is a proper standard practice, whether or not penalties are actually sought in the end or not.
And I wasn't meaning to imply that staff was inappropriate for asking or that they shouldn't ask. I did notice in the pleading that they said they did not recommend a particular amount of penalty and that they would recommend leaving that up to the commission. So I certainly understand that. I'm just questioning the value of it as a deterrent and whether we're targeting the correct or whether we're deterring the correct group when people are just building wells and walking away from them.
In Missouri, with wastewater and with drinking water, if you can meet the standards, you're allowed to construct such systems. It's not that way in every state. And that does allow for a lot of problems. When I was with DNR, the federal emphasis was on oversight of the largest systems, big cities, that sort of thing. Whereas the vast majority of enforcement efforts were spent on the very small systems, as you described. It's a problem and it will continue to be a problem. But as far as the seeking of penalties for a situation like this, in my opinion, it becomes more appropriate when folks don't, once informed of the rules, don't change their activities, when they continue to charge for service, when they may apply for an application and then withdraw it. That to me demonstrates that someone is still willing to break the law, and then maybe a deterrent is appropriate.
Now you had indicated in your testimony that and I'm paraphrasing you because I can't remember exactly how you said it, but you said that there were two reasons that people didn't comply with regulations or doing what they're supposed to do, and one was a lack of ability, and I believe the other you said they just don't want to.
A lack of will.
Yes, thank you. Which is it with Mr. Blevins?
I don't have a firm grasp on which it is. I don't know for certain what his financial status is. I don't know. I don't know why a person wouldn't immediately call a contractor to come in and fix a problem, or wouldn't immediately reach out to a civil engineer to address a problem if I was responsible for those customers' health and safety. I have not attempted to do an asset search. I haven't tried to find out what things or what resources Mr. Blevins has. He's not registered businesses, and he's not subject to our regulation yet, so we can't do an audit. We can't get into his books. So I don't know for certain. I believe, personally, that when he has fixed things after some amount of time, that demonstrated a lack of will to do it faster.
Now, you were here for testimony yesterday, at least for
Yes.
a large part of it. Now, were you here when Mr., is it Grubbs? Grubb?
Grube, yes.
Thank you. You were here when Mr. Grubb testified?
Yes.
And were you here when he indicated that he had called somebody about a problem, and they said they were going to do something about it, but that Mr. Blevins owed him $20,000?
Yes.
And I believe during the receivership hearing, Mr. Blevins had expressed that there were certain things, such as getting an attorney for this proceeding, that he just could not afford to do.
I don't specifically recall. I know that he had an attorney at some point, but I believe he said he no longer has one. I don't specifically recall what he said about being able to afford an attorney during that proceeding.
But he did get a system operator
He did.
when he was told
Yes.
to. And that system operator was sending in samples. So even half-heartedly, it looks like he was making an effort in the direction, correct?
Correct.
I kind of want to talk a little bit about the receivership and the sale. And that's because also in the receivership hearing, and as he expressed in opening here, he's 80 years old. In the receivership hearing, he expressed that he was 80 years old and he was looking to retire from this business and move away from it. You indicated you've discussed with companies that may be interested in purchasing his system. He's indicated that he is wanting to get out of the water business. Have you discussed, has staff discussed with him putting these two together?
No. I don't have any faith based on my personal experience, DNR's experience, that Mr. Blevins would actually voluntarily do that. Mr. Blevins says a lot of things.
But that's your belief. You haven't tried, so you don't know.
No, I have not asked companies to ask Mr. Blevins if he would sell the wells to them, no.
And this gets to my next question. I have absolutely no idea what the answer is when I'm asking this. Would a company that's planning to purchase another water system, would they be more likely to act as a receiver for that system if they knew they were going to be purchasing it?
I thought there was problems with that, legal problems. I don't know that they can they?
I don't know. I'm asking the question with no legal research behind it whatsoever.
I don't know the answer to that. It seems like that would be a conflict because the receiver is supposed to be finding that buyer and getting an appropriate price for the assets. And if the receiver was also the buyer, wouldn't they be trying to undervalue those assets?
I think those are all good points, and you may be exactly right. I'm not sure. I'm just asking the question. Okay, let's take the receiver out for a second. If you're just talking about a straight up purchase of a system by a larger system that has an existing CCN, and I guess they would be moving to expand their CCN and purchase, how long of a process are we talking about?
At least 90 days, probably Probably closer to 120 or a little bit more. Some of that is time after staff completes their investigation and provides information to the commission, and that appears on agenda and such. But since we already have a lot of staff already has a lot of familiarity with, in this case, Mr. Blevins' systems, our portion of it would be pretty brief. But a company would have to be coming in and evaluating things like what easements exist, is there clean title to all the property associated with that? So their work ahead of filing an application would be significantly longer.
Thank you. I don't have any further questions for you. Mr. Blevins, do you have any cross-examination questions based upon questions I've asked?
No, I don't. Thank you.
Any redirect from commission staff?
Yes, I have a few questions. Now, you had testified about, or one of the questions was asked about another company filing something, or you getting a company to file something, like a CCN. Staff doesn't do that. It would be up to the company to file that, right?
Correct.
Staff can just suggest it. But staff can't order a company to, or can the commission order a company to?
The commission can order a large utility to acquire the assets of a small utility in certain situations, but this is not a situation where there is a regulated utility to be acquired. So I don't know that statute would come into play.
Okay. And about how long ago did staff become aware of a company that might want to be able to buy out this take over or buy Mr. Blevins Systems? Is that recently or?
Less than a year, months, within the past few months.
Okay. Now, when there was some testimony about how many customers, and I think one of the numbers that was thrown out was about 50 households. Is that separate than the number of customers? And then you said 100, about 100. So are we counting them differently? I mean, are there 50 customers or are there?
We believed there were approximately 100 customers based on our field investigations of the customers that we understood that Mr. Blevins was billing for service, and literally counting homes when we went out there and looked at these. Sometimes it's a little hard to tell if a house is actually connected to that well or not, so we had guesses of approximately 100. Since that time, some folks have formed their own HOA. It's my understanding that Mr. Blevins may have sold one of the wells. I mean, that number is fluid, but we don't know for an absolute certainty how many customers at peak that he might have provided service to, and I don't know right now how many he provides service to.
And while the customers might be one household, there'd be multiple people within that household, right?
Certainly.
Okay, so it's really 50 times whatever number of people are in a household.
Correct.
Whatever
The
name.
state assumption with DNR, I believe, is 3.5 or 3.4, something like that.
Okay. Now, you had just indicated that he did obtain a certified operator, but he's no longer has one.
Correct.
That was the testimony. Is that something that staff would expect him to be able to do?
Absolutely. And I am certain that a company with appropriate resources that could obtain the services of a contract operator. Now, that may be more expensive if you can't hire someone locally, but There are water systems in Pulaski County who have operators. There are operators in the surrounding counties. There are operators who operate the drinking water system at Fort Wood. There are people who have the ability. But a lot of times when we have very rural settings, not only are the bills higher for regulated companies because of fewer customers to divide the cost over, but also it costs more to provide that service out in some wonderful place to live instead of where they wanted to build a house instead of in a city with a whole bunch more folks. They may have to pay a contract operator to drive. And we have companies that do that right now. But the idea that a operator, it's impossible to obtain one is, I disagree.
So, Mr. Blevins, so there are possibilities for Mr. Blevins that you know of to get a certified operator right now?
I have seen it demonstrated that other folks can do it.
You'd stated to Judge Clark that staff, we're not driving around the state searching for systems that should be regulated by the PSC. So as a result of that, would you say that there is always a possibility that there are water systems that should be regulated by the PSC that we don't know about?
I am all but certain that it still occurs, yes.
So you would say that it is likely that there are other systems out there that should be regulated?
Yes.
Has the PSC, in your experience, previously discovered systems with long-standing operations that should be regulated and should have been regulated for a number of years?
Yes.
In the event that Mr. Blevins were able to structure his systems with these HOAs so that they would not fall under PSC regulation, he still owns wells that would fall under PSC jurisdiction, correct?
Correct.
And you may not be able to answer this, but do you believe that it would be easier for staff to locate a receiver if they were aware that there was a plan for the system to be purchased?
That seems reasonable, yes.
Okay. And you had stated to Chair Hahn that this is an unusual situation as far as a receivership, that frequently that's entered into voluntarily, is that correct?
Correct.
Were you part of the discussions about filing a complaint against Mr. Blevins?
I was.
And I would say particularly with small utilities, do you think that it's fair to say that filing a complaint is a last resort as far as solving a problem that has arisen?
No matter what, that's going to depend on the nature of the problem.
Okay.
If it's a health and safety issue, it would be the normal course of action for DNR to issue their findings expressing the situation, the problem to the company. And our involvement as working with DNR's in front on that. So they are trying to get the problem addressed. If a company is unable to comply quickly or chooses not to take the appropriate actions, then if people's lives are at risk, I'm going to be starting my work as quickly as I can, but we're always in contact with those companies before such a filing would occur.
So would you say that while it may appear from the outside that it is staff's first choice or an early choice to file a complaint, that may not actually be true because there are other things happening with other state agencies such as DNR?
Yes.
Okay. No further questions.
It is now 10:55. I think it's a good time to take a first recess, so why don't we break until 11:10? When we left off, we had just finished with staff's witness, Kurt Gately. Staff, I believe you have one more witness, is that correct?
Yes.
Would you like to go ahead and call that witness?
Yes, call Adam Stamp.
Mr. Stamp, if you'll come up to the witness stand and raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth? I do. Please be seated. Staff, go ahead.
Thank you. Could you please state your name and spell it for the record?
My name is Adam Stamp, ADAM, STAMP.
And by whom are you employed and what's your position?
Missouri Public Service Commission.
What's your position?
I think officially I'm classified as an analyst. Mr. Gately typically uses me in more of a inspector, field investigator type of role.
Okay, and what kind of duties and responsibilities does that include generally?
I investigate a lot of complaints like this one. Other times, such as acquisitions, I'll go out on site and take a look at whatever system is in the case. Other times, more just routine visits to companies to check in on routine operations.
And are you familiar with Leon Travis Blevins?
I am,
And what about Misty Waterworks?
yes.
Okay, and Misty Mountain, there's been some discussion about Misty Mountain, Misty Waterworks. Can you kind of explain
Yes.
that?
What I would say is that Misty Waterworks is the company that Mr. Blevins typically does business under, a DBA, I guess. Misty Mountain is a neighborhood and a water system that feeds it. So when we say Misty Mountain, we're talking about a location. When we say Misty Waterworks, we're talking about Mr. Blevins' fictitious company.
And do you know if that company has been registered with the Secretary of State?
It has not.
And you're familiar with what's been, or the Outlaws Corral?
Yes.
And what is that? In
Mr. Blevins has used it on the letterhead of notices that he sent to some of his customers. As far as I can tell, that is the name of his office that he runs operations out of.
And do you know if that's been registered in any way as a business entity with the Secretary of State's office?
As far as I can tell, no.
Does he have any of his business entities or any of his well systems registered as business entities with the Secretary of State's office?
Other than his attempt at the recent HOAs that he wanted to form, no.
And when did you first become familiar with Mr. Blevins?
January of 2023.
And how did that come about? What were the circumstances with you getting involved?
DNR asked the PSC for assistance in their investigation into Mr. Blevins, and Mr. Gately assigned me to it.
And so Mr. Gately explained what it means to be operating as an unauthorized water utility for PSC purposes. You're here for that testimony?
Yes.
Would you say that Mr. Blevins is operating an unauthorized water utility?
So I immediately found in my investigation back in January of 2023 that Mr. Blevins had willingly put himself in a situation to where he was responsible for water service to hundreds of his neighbors. He was charging them for that responsibility. They were paying him. And for reasons that some he can control and some he cannot, that service was not safe, reliable, or adequate.
Okay. And so how did you find out that he charges his customers or charges these households for water usage?
Customers would give me the paperwork that he had given them.
Okay, so as part of your investigation.
Yes.
And so under his operations, does a household is being charged a flat fee? Is that right?
Yeah, I would call it a monthly fee. As a customer discussed yesterday, they typically pay in advance, but if I were to describe the way he bills, it would be by the month.
Do you know if that's based on any kind of usage or quantity of water used?
No, I've seen paperwork where costs might increase based on if the customer had a pool or livestock, for example, but otherwise it's just a flat rate.
And there was some testimony about some of the rates being different for different customers. Did you find that in your investigation?
Absolutely.
And did you try to figure out why Mr. Blevins was doing that? Or did you get any information about why he was doing that?
It was difficult to tell. Next door neighbors on the same system might be paying a different rate, and usage is not measured in any way. So it was difficult to understand the reason behind it.
Did you ask Mr. Blevins if there was a reason behind that?
No,
Did he give you any reasons?
no.
And you said you received documentation explaining that he charges the residents for this water service. How and when did you get that information?
How and when did I get?
The information or the documentation that shows that Mr. Blevins was charging the residents for water service?
Customers have been very forthcoming with any documents that Mr. Blevins has sent to them.
I'm going to hand you or Ms. Aslan's going to hand you what's been marked Exhibit 13. Oh, wait. Are these all of them? Oh, what is this? What's all of them? There. And before.
I hate to interrupt you, but I have a question. Do you ever offer Mr. Gately's testimony?
I thought I did, but if I didn't, I would offer it, be entered into evidence. At this point.
Mr. Blevins, do you have any objection to admitting Mr. Gately, the previous witness's testimony from the previous hearing into evidence in this case?
No objection.
I guess
Exhibit 12 is admitted onto the hearing.
okay, so that was 12, and then this would be 13.
No, you had the numbers right. Either I didn't make a notation that it was in fact entered, or it wasn't entered. But
Okay,
either way.
I thought I did, but I might have just skipped over that.
Either way, that's remedied now.
Okay, thank you. Okay, so, and what I've handed you, that's being marked, that's been marked as Exhibit 13. And for the record, that exhibit would be confidential, has confidential information in it, so. So I'll point that out.
Thank you.
Do you recognize what's been handed to you as Exhibit 13?
Yes.
And what are they?
These are customer complaints to the PSC.
And how many, are there separate complaints there? How many are there?
There are several separate complaints.
Okay. There's 7 of them? Are they all separate, different complaints?
They are.
Okay. And there's 7 separate ones there? I think that's what I counted.
I believe that is correct.
Okay. And are those received by and kept in the the PSC's normal and ordinary course of business?
Yes.
And when did does it show whether or when customer service, who received these? Can you kind of tell me what these complaints are? Just generally what it is? Not what the substance of the complaint is, but just generally what that document.
Okay, these are basically part of why the PSC exists. Customers that are unhappy or have a problem call into the PSC to make a record of a complaint.
And those are received by the Consumer Services Department?
Correct.
And were these the customer complaints that were received with regard to Mr. Blevins?
Yes.
And just generally, what are the individuals complaining about? Or what are their complaints? You know, what's the substance of their complaint?
With these particular complaints, it's more focused on a rate increase in their bills and the fact that they did not believe that Mr. Blevins owned the wells that they get their water from. So they were confused as to why he would send them a bill.
I ask that remove that Exhibit 13 be entered into evidence as a confidential exhibit.
Mr. Blevins, do you have any objections to admitting Exhibit 13C into evidence?
No objection.
Exhibit 13, confidential, is admitted into the hearing record.
And were those complaints really what started your investigation? Or did your investigation start immediately after that?
Actually, it was a little bit before this when DNR came to the PSC asking for help.
Okay, and then,
But this pretty much coincided with that.
were these complaints requested by the PSC in any way? Or they,
No, unhappy customers called the PSC.
on their own,
Yes,
as far as you know?
yes.
And so that you got involved in as an investigator. Did you speak to, after you got those complaints, did you speak to or meet with Mr. Blevins at all?
We met with Mr. Blevins in April of 2023.
And have you met with him since then?
Briefly, we've had multiple situations like this, but otherwise, no.
And when you did, sorry, and you said,
Hold on just a second. When you say situations like this, when you say in here,
I apologize, Judge. Yes,
okay, so you haven't met him again outside of here?
no.
Okay, thank you for clarifying.
and when you met with Mr. Blevins, was that with Mr. Gately as he was testifying?
Yes.
And can you tell me what your impression of that meeting was?
I would call it positive, I guess. When we left that day, we had hoped that Mr. Blevins would properly apply for a CCN and that we would move toward regulation, which would lead to, better service for the customers and hopefully better business practices for Mr. Blevins.
Okay, did that seem to happen?
No.
Now, did you speak to any of the individuals who submitted those complaints?
Yes, I've spoken to most of them.
And did they give you more information or more documentation at some point?
Yes, over time, we've had a tremendous amount of documents from customers on all of Mr. Blevins' systems.
And how often would you receive information from those customers? I mean,
Multiple times per month.
And are you still receiving those kinds of information, that kind of information?
Yes, on a near weekly basis.
Ms. Allen's handing you what's been marked Exhibit 14.
Thank you.
I would also note that this exhibit should be also marked confidential. Do you recognize what was just handed to you?
I do.
And can you just tell us or tell the commission what is included in that packet that I handed, or that you were just handed?
The first page is basically a notice to inform the customer that your water supply is coming from Misty Waterworks and you will be billed for it. Do you want me to go on? Second page.
Yeah, just
Okay.
generally what's in those documents.
Okay.
I mean,
Second page is a notice to customers that their water system is now being enrolled as a DNR certified public water supply system. And due to that, their rates will be increased. The third page is an agreement to furnish water, and you will see down below that there are dollar amounts listed.
And then the last two documents are,
The final pages are notices of transfers of ownership to let residents know that their well that supplies their water is now owned by a new entity,
and that new entity was,
Mr. Blevins.
and when did you get those documents? I know they have dates on them, but
I would have received these in January and February of 2023.
so at the beginning of your investigation?
Yes.
And who did you get those documents from?
From the customers.
Okay. And did you receive them in the normal and ordinary course of business as a staff member working for the PSC?
Yes.
And are those kept as your records or as PSC records in the normal and ordinary course of business?
They are.
And what do they show about whether Mr. Blevins was operating as a utility?
Seems pretty simple. Mr. Blevins is providing water service and charging people for it.
And does it have information in there about paying Mr. Blevins for the use of that water?
Yes.
Is there anything in there about whether he was charging late fees or any extra fees?
As far as extra fees go, if you look on the back side, about halfway down of the first page, you'll see mentioned additional charges for swimming pools.
In that second paragraph, sorry, not the second paragraph.
Number two, same page. There is additional charge for late fee.
Okay. And these documents were included as attachments A through F to the complaint that was filed in this case. Is that your understanding?
I believe that's correct.
I'd ask to admit Exhibit 14C, I guess, into evidence.
Mr. Blevins, do you have any objections to admitting Exhibit 14C onto the record?
No objection.
Exhibit 14, confidential, is admitted onto the hearing record.
Thank you. And did you talk to Mr. Blevins about those documents?
Briefly.
And did he say anything about them? I mean, did he disagree? Did he have an explanation?
It seemed pretty straightforward. Mr. Blevins was providing water service to these people. These were the documents he was sending them as his customers.
Did he tell you how long he'd been doing this?
He's mentioned various numbers. I think 15 years has been thrown out there. Not certain on a number.
Okay. Now, during your investigation, did you have contact with other residents besides these that filed complaints and these that you received the documentation from?
I've spoken to numerous residents.
Do you know about how many?
If I had to put a number on it, I would guess around 30 or 40.
And did you contact them, or have they contacted you? How did your contact, what kind of contact do you have with them?
Most of the time, they've contacted the PSC.
Now, over the course of your investigation, have the calls increased, decreased, stayed the same?
Increased.
And can you explain that? Like, how have they increased? Is there a proportion?
Yeah, I guess at the beginning, I would hear from customers maybe a couple times a month. Now my phone typically rings every few days.
And did Mr. Blevins, or did any of these documents tell you anything about the ownership of the wells?
He on the final page of the document you gave me, he mentions that he now owns the wells in question.
Do you know whether he owned all the wells that were providing water for which he was charging a fee?
So at the beginning of my investigation, we've never been certain how many wells Mr. Blevins claimed to own or charged people for service from. We thought that it was probably around 20. Initially, when I started investigating it, I checked county records and found Mr. Blevins' name on maybe a little less than half of those.
And did you, I'm sorry, and we'll get into the ownership a little later, but what did he tell you about his ownership of the wells?
I think it was mentioned earlier, some were handshake deals or understandings from a long time ago. I think in a lot of situations, people just weren't sure. I know we had a customer yesterday that said no one knew for sure until they went to the county and searched records.
And did he indicate that he owned all the wells that were providing water to his quote customers?
I guess he probably thought so, but I don't know that even he was certain of that.
And there was a public meeting that we've discussed several times with different witnesses that was held in June of '23. Were there any other type of formal gathering or any other type of formal information gathering that you conducted?
Formal, no. It's been a lot of myself meeting one-on-one with people.
Okay. So about the public meeting that was held in June of 2023, is that something the staff normally does with, when it gets complaints?
I would probably call it rare, I guess. I have not been with the PSC for a really long time, but it's the only one I've seen so far.
Okay. And do you know why it was held? Why staff decided to have a public meeting or an open house? Whatever you want to.
For a couple reasons, I would say the first would be that there was a lot of various information from a lot of sources, and no one was certain of what was true. And PSC staff thought that if we could gather everyone and just listen, maybe we could go on a fact-finding mission there. The other reason was that just the extreme discontent that customers were showing. We just wanted to give them a chance to speak.
And about how many residents were there in attendance? Do you remember?
So it's a pretty large room. It's an old repurposed movie theater in Waynesville, and it was so full that there were people out of the door. Standing room only may not even be a applicable way to describe it. It was there were a lot of people in there.
So did all the people that you did you send an invitation or notice out to the residents telling them about the public meeting?
I asked Mr. Blevins for his customer logs, and we used the addresses from those customer logs to send those customers a letter to let them know we were going to hold a meeting. Whether or not Mr. Blevins gave us complete customer logs is unknown.
And do you have a reason to think that there were customers there, or the customers should have been invited or notified that weren't?
Based on some information I've seen since, I do think that maybe he withheld some customers.
And which customers would those be? Do you know?
One particular system called Rejoice, and I've asked Mr. Blevins about this system myself. He claimed to not serve the people there. As far as I can tell, he is.
And what causes you to believe that he is serving them?
He according to county records, he owns the well there, and there were complaints in the past from people on that system, way in the past, pre our investigation.
Okay. And but you didn't get those customers' information when you asked for his customer list?
Correct, and I asked Mr. Blevins myself about that particular system, and he told me that he did not serve those people.
And would you say, what percentage of his customers would you say attended that meeting?
Based on the paperwork I've seen since I started my investigation, and again, that paperwork may not include every customer, we found around 100 connections. So based on what Mr. Gately said, I guess you figure 300 plus people. I think there were probably over 100 people at that meeting. If I had to guess, maybe around 50 to 60% of his customer base.
And is that what you're expecting?
Well, based on my experience with the PSC, when we hold hearings or informational meetings like that, a 60% turnout of the customer base is rare.
What percentage usually shows up? Could you say?
A lot lower than that.
Okay. And did that surprise staff in any way, or?
I think it made it very clear to us how unhappy the customers were, how, I guess, maybe volatile the situation was.
And what kind of information did you get? What did they want to know?
There were a lot of service complaints, of course, which has been a common theme. But they also could not understand why almost every single person was paying a different amount, even customers that were on the same water systems.
Did they tell you that?
They were also very surprised at how many other people were in attendance. They had no idea that Mr. Blevins' scope of business was that large.
And how did you find out about the different monthly payments? Did they tell you, or?
They told me.
And DNR had staff at the public meeting, right?
Yes.
Okay. And would you say that, and both the DNR witness and our witness, Ms. Johnson and Mr. Gately, talked about DNR being at that attendance? What was your understanding of what their role was there?
Excuse me. DNR was, I guess, a little more focused on the quality problems that Mr. Blevins has had. Quality with his water. While we were, I guess, maybe a little more focused on the safety and monetary aspect of it at the time.
Were you trying to determine the scope of his enterprise?
Yeah. During your investigation, did you not have an opportunity to do any site visits? I've done a lot of site visits.
Okay. Do you know about how many you've done over the course of the last, was it year and a half of your investigation?
10, probably.
Is that compared to other investigations? Is that about average for number of site visits per investigation, or where does that fall?
I would probably call it high.
And why would you say that?
Well, part of that has just been the continuously ongoing investigation that we're at 18 months now, and since I'm assigned to it, I make sure to stay updated on whatever's going on. In addition to that, since customers continue to call me on a weekly basis, I want to stay involved and stay informed in what's going on.
And did you take pictures at any time when you were at the site visit, doing these site visits?
I have.
And were you the only one taking pictures, or did other staff members take pictures?
There have been times when other staff members have taken pictures as well.
Okay. And did you see the wells that were part of the Misty Mountain Charity and Rolling Hills Public Water Systems?
I have.
And did you see wells that were not regulated by DNR, but that were supplying water to the homes?
I have.
Okay. So where are these wells located?
So if you take St. Robert and draw an arc or make an arch around the top half of it for about, say, 20 to 30 miles, most fall within that arc
Okay, so,
that we know of.
and so they're located pretty much within that 30 mile radius?
Yes.
And some of them are owned or supposedly owned privately by Mr. Blevins that are not regulated by DNR?
That's
Is
correct.
that your understanding? Okay. Can you when you did go to some of these sites, can you describe what you saw or what you observed about the sites?
It varies. Some of his sites are fairly well kept. Others I would call in disrepair.
Could you describe what you mean by that?
Very dirty, unkept, dilapidation, just general lack of maintenance and cleanliness.
Was there any safety concerns or any other concerns that you'd see when you went to look at these sites?
Yes, some are exposed to where, well, for example, some of the well houses maybe don't have roofs, so wildlife or whatever can get in and tamper with the head of the water distribution system. Others, a lot of exposed wiring all over the place can potentially make for a hazardous situation. And just general uncleanliness, trash in the well houses,
Okay,
things like that.
that concern you?
Being that he's in charge of providing water to people, yes.
And how come? I mean, why is that a concern?
I think something as important as giving water service to customers probably requires a little more attentiveness, the ability to do a better job of staying on top of things.
Did you expect the well houses and the wells that you visited, did you expect them to be, what did you expect them to look like versus what, was it different than what you saw?
Well, some of Mr. Blevins' wells are in okay condition. They're locks and completely enclosed wells on a concrete pad. Others, like Misty Mountain, for example, the houses are falling apart, or all of the water equipment is completely exposed to whoever or whatever. And again, just parts and trash laying around.
Is that what you would expect of a water utility?
No, not typically. I don't see that in other systems I look at.
Okay. I'm going to have Ms. Aslin hand you what I'm going to mark as Exhibit 15. And do you recognize what's included in Exhibit 15 there?
I do.
And what are they?
These are pictures of the inside of the well houses in question.
The ones that, did you do, are all of these pictures, were the pictures taken by you or obtained by you as the part of your duties in the normal and ordinary course of business?
That's correct.
And are they kept in your files and records of the PSC in the normal and ordinary course of business?
Correct.
Now, did you take these pictures?
These were sent to me by a customer.
Okay. All of them? What about the first one? Is that one that you had gotten when you went out with another staff?
I did take this one, yes.
Okay. And what are the, you said you got the last several, last three pictures? You said they came from a customer?
That's correct.
Did you ask for them, or?
No,
How did it-
no. Customers have due to how unhappy they are, they've been very forthcoming with information.
And so what was the reason, do you know what the reason was for this customer sending you the pictures?
I would call it extreme discontent.
Okay. Is it usual, in your experience, do you usually get these, get pictures and this type of information from the customers that are complaining?
It just depends on the situation,
Okay.
the severity of the complaint.
And if you can go through each picture and just kind of say, explain what the pictures show
Okay.
to the commission's, yeah, just for the commission's understanding.
The first picture is one that I took. You can see here, well, it might be hard to see, but a lot of leaks you're looking at the well and the distribution system, or the head of it anyway. A lot of leaks and the associated algae growth on them, so they've been going on for a while. In that same vicinity, there's a lot of exposed wiring and electrical connections. Also, in a broader scope, just the uncleanliness of the whole house there.
And what about the other pictures? What did they depict?
These pictures were sent by a customer. The second one kind of shows the same thing as the first. The third is significant because the well house is completely open and exposed, and the power source that's making the well run it just runs out the opening here and can be easily severed or tampered with.
And did you see that was there a door on that well house?
In the picture, there is not.
Did you visit this well house at any time?
I have at some point.
Okay, do you remember?
I've seen changes in the last 18 months,
Okay.
especially since DNR and PSC started putting pressure on Mr. Blevins.
Okay. And what's the last picture? Is that the same, just a picture from further out? Or what's the difference between the two pictures, the last two pictures?
Yeah, the second picture is a closer view of the inside and the system. Again, all of those exposed connections and water leaks and very dirty. And the third picture shows the easy access to the well house and the fact that the wire powering everything is completely exposed and easy to access.
I'd ask that Exhibit 15 be entered into evidence.
Mr. Blevins, do you have any objections to admitting the photographs of the well house, Exhibit 15, onto the hearing record?
No objection.
Exhibit 15 is admitted onto the hearing record.
Okay, thank you. And I guess with regard to that exhibit, looks like there's a Gmail address of the person that sent the email. I don't know if that needs to be, if that makes it confidential, but just to cover just to be sure, I might want to ask, I think I might ask that be marked confidential, just to make sure. Is that,
I'm sorry. Say that again, please.
since the second page, the email of that exhibit has a individual's email address on it, I think that one, Exhibit 15, should probably be marked confidential as well.
I think that's appropriate. Thank you for bringing that to my attention. Okay, Exhibit 15 will be marked as confidential.
Thank you. And entered, is that entered? Okay, just want to make sure.
I already admitted Exhibit 15 onto
Okay.
the hearing record.
All right. So what kind of concerns did seeing these wells and getting this information from customers, what kind of concerns did that raise for you or raise for staff?
Compared to what I typically see with other companies, these are pretty dilapidated. Looks to me like sort of typical maintenance and cleanliness have kind of been ignored.
And why would that concern the PSC?
Because that eventually has an effect on customers' water service, on the safety and adequacy of it.
How so?
Well, we've seen a lot of reliability problems. We've also seen problems in quality with the water.
And did you just discuss any of these problems with Mr. Blevins or your concerns with Mr. Blevins?
We have.
And what was his reaction? Or what was his response?
Typically, when the customers had water, Mr. Blevins hasn't shown a tremendous amount of concern for anything further than that.
And what do you mean by that?
Well, the quality issues, for example, when the customers on Misty Mountain were dealing with bacteria in their water, this went on and on for months. The Taylor well failed in 2019, and it remained down until 2 weeks ago.
Did he fix some of the other problems? That were pointed out to him?
He has repaired some problems.
And what about, has he not repaired some?
Again, I would say the Taylor well is a fine example. It was down for 5 years. And again, kind of what I said earlier, in the last 18 months, as the PSC and DNR has, I guess, pressured him, if you want to use that term, he's cleaned up a few things.
And does he, okay. Did you have contact, besides the customers and Mr. Blevins, did you correspond or have contact with any other, anybody else, any other entities?
Yeah, some well service providers, DNR, the county, the public water supply district.
And what, can you tell me about what happened there when your contact with the county water district?
Yes, they acknowledged that they would like to be the supplier for all of the folks on Misty Mountain, but that it just wasn't feasible at this time.
And did they give you an explanation why it wasn't feasible?
Geography is probably the biggest thing.
Okay. So is that does he expound on that? What about the geography that they say is not feasible for them?
Okay. Well, ground that's really hard to dig through. A lot of elevation changes, just very long runs of line.
Okay, so that, and all that would have to be done by the county
Correct.
to provide water to everybody that he
For-
services?
And for not that many customers. Correct. Yes.
Now, you said you've had contact with the DNR, and there's been quite a bit of testimony about that. How often were you in contact, or how often did you have contact with DNR or work with DNR during your investigation?
I would say multiple times per month.
Okay, and could you describe that contact? How would you describe that?
Basically just sharing of information because unhappy customers have contacted both of us. Customers don't always know the proper avenue for complaints, so they may contact DNR, they may contact us. Since both of us were working on an investigation involving Mr. Blevins, we shared information.
Okay. And so you've been, and how has that worked out?
Okay.
Have you gotten a lot of information back and forth?
Well, it was DNR that originally referred us to this situation because they saw the quality issues with the water, but they also recognized that Mr. Blevins was operating a water utility business and was not regulated. So that is why they approached us.
And what, have you contacted any other county offices during your investigation besides the water district?
We've, because of all the unclear property rights situations in this case, we've talked to the county collector and the county recorder as well.
And what information, just generally, what information did you expect or were you looking for when you contacted the collectors and the recorder's office?
It's always been uncertain since the beginning of this case of whether or not Mr. Blevins had the right to charge people for the water, and whether or not he owned the wells that that water was coming from. So we've continuously tried to find out whether or not he actually owned the wells that he claimed to own.
Okay. And you contacted the collector's office, right? The Pulaski County Collector's Office?
Staff did, yes.
Staff. And what information were you looking from the collector's office? Or what information might they have that would help you?
That way we could look at property tax information. We would have an idea of what Mr. Blevins owned and had paid taxes on.
Okay. Ms. Allen's going to hand you what's been marked Exhibit 16. Can you tell the commission what those documents are?
These are real estate tax statements.
And was that what you received from the collector's office?
Correct.
And did you obtain those records in the normal and ordinary course of your business as an analyst with the PSC?
Yes.
It was part of your work as part of your work in this investigation, right?
Yes.
And what information did they provide?
It shows that Mr. Blevins and his wife do indeed own some wells.
Okay, now how many different pieces of property were taxed that you could tell from the collector's records?
Based on these papers, I see about 5.
I think there's 4, maybe.
Okay.
And so he's being assessed property tax, as far as you know, for 4 properties. At least that's
Yes.
what you found out, right?
Yes.
Okay. And according to their records, has Mr. Blevins paid the property tax on all 4 of those properties?
I believe some are delinquent.
And I believe there are 2 that have been paid and 2 that have not been paid. Is that what your understanding is?
Yes.
And which, the 2 that have been paid, is there something different about those 2 properties that you found out compared to the 2 properties that have not been, where the taxes have not been paid?
Just location of the well is
Okay.
all.
Was there anything about the ownership of 2 of those wells that was different than the other 2? It might not show it in these documents, but did you find that out?
Mr. Blevins appears to be the owner of these wells.
Um, Did you find out whether he's the sole owner on all 4 of those wells? Or he and his wife are the sole owner?
His wife as well.
Okay. Um, And there were 2 properties that the taxes had been paid. Did you find out that somebody else also owns those properties with Mr. Blevins?
I don't recall.
Okay. All right. There's one has a tax delinquency of 3 years. Do you know what? Can you point to which one that is? Does it say there on the document?
I'm not able to find the date at the
Okay,
moment.
I think they're it's at the top of the document.
Okay. Okay.
Okay, and so at least one of those has tax delinquency for 3 years, for the last 3 years, right?
That's correct.
And does that concern you? Would that be something of concern to the PSC?
I guess if the water provider is in danger of losing ownership of the source of water that they're providing to their customers, I guess that would be concerning, yes.
And okay. I'll ask that Exhibit 16 be admitted.
Any objection, Mr. Blevins, to admitting Exhibit 16, the Pulaski County Real Estate Tax Statements, onto the hearing record?
No objection. No objection.
Exhibit 16 is admitted onto the hearing record.
Okay, now Ms. Aslin's going to hand you what's been marked Exhibit 17. And what do those documents show? Do you like-
It appears to be a transfer agreement.
Are those the records that you obtained from the recorder's office?
Yes.
And When you asked the recorder's office for information, what specifically did you ask them for? What types of records did you ask for regarding Mr. Blevins?
Any documents that showed property ownership?
That he was the grantee?
Correct.
Okay. And this is what you received from the recorder's office?
That's correct.
Do you know if there's anything else besides these? When did you get these? Do you remember?
2 weeks ago, probably.
Okay. And do you know if there's been anything since then, or?
I've heard rumors from customers, nothing that I can substantiate
Okay.
at this time.
And are those records, records that you got in the normal and ordinary course of your investigation?
Yes.
And you keep those records in the normal and ordinary course of business as the PSC?
Yes.
And how many different documents are there?
How many different documents are there here?
Did you get from the recorder's office? Are those all the documents you got from the recorder's office?
So far, yes.
Okay. And what do you mean so far? Were these
With customers claiming that there are ongoing deals and new situations that are arising, it's likely that we'll speak to them again.
Okay, but these were all the documents you received from the recorder's office?
That's
There aren't any
correct.
other documents that the recorder's office had that you didn't get, that you know of?
To my knowledge.
Okay. And, there are 9 separate documents that you received? Is that right? Is that what's in there?
Probably so.
Okay. And do all of the, do they all seem to convey land that you can tell? Or some of them, other documents that may or may not convey land?
I guess I wouldn't necessarily say just land. For example, this first sheet is refers to rights and obligations.
And those are rights and obligations to do what? What is that conveying?
Supply water.
And the first one talks about concerning the water well that supplies water to, well, they all, in that first document, where it's transferring all rights and obligations, it says concerning the water wells that supply water to, and then it lists several addresses. Do you know what, can you tell from that document, or do you know what well that refers to?
I do.
Is there a legal description about what well that, how do you know that? Do you know that from the document or from?
This, based on my searches of county records and actually from Mr. Blevins' customer list that he gave us. He at one time owned this well.
Okay, but this document doesn't exactly show which, doesn't have any legal description or doesn't describe what well is being transferred, correct?
That's correct.
And then I think there were 2 other warranty deeds. What are the other documents that aren't warranted? So there's the one well transfer agreement that we're not sure what well it actually, or what wells it actually transfers. And then there's 2 warranty deeds, right?
That's correct.
And other than those two those warranty deeds transfer land or property, as far as you can tell, correct?
Correct.
Okay, so there's the two warranty deeds and the well transfer agreement. What are these other documents? Agreements to furnish water?
They appear to be agreements, sort of the same, some of the same agreements that we saw earlier, in other documents. Agreements to furnish water, their dollar amounts listed below.
Do they seem to transfer any kind of property or land?
I don't believe so.
So these are similar to the ones that, that you received when you started your investigation from the different customers, is that?
Some of them, yes.
Okay. But they're all, the agreements to furnish water, what stands out about those, if anything?
What would interest me as a PSC employee is that Mr. Blevins is agreeing to furnish water, and that he expects payment for it.
Okay. But, and these were recorded with the recorder's office,
That's correct.
but to your knowledge, that doesn't refer to any particular land transfer, does it?
Correct.
I'll ask that Exhibit 17 be entered into evidence.
Mr. Blevins, do you have any objection to admitting Exhibit 17 onto the hearing record?
No objection.
Exhibit 17, the well transfer agreement and agreements to furnish water are admitted onto the hearing record. Is there anything about these that needs to be confidential in nature?
Well, I don't think so. I mean, they're public records. So I think anyone could get that from the recorder's office, so I don't know if,
I'm just wondering if some of the names in here are customers.
they are. So if, to be safe, we could mark them confidential, but like I said, they're public records, so.
It's kind of an iffy line because, I mean, it's one of those things where they're public records, but we also have our PSC rule that
Right, in
says
this
that
case-
this particular item is confidential.
Right,
So I'm going to go ahead and out of an abundance of safety, go ahead and mark it confidential.
okay.
So Exhibit 17 confidential, the well transfer agreement and agreements to furnish water are admitted onto the hearing record.
So the information you got from the recorder's office was, is that what you were expecting to get from the recorder's office? Just two warranty deeds and a bunch of agreements to furnish water?
Honestly, I did not know what to expect. Ownership and rights have been extremely difficult to understand in this case, and they are ever changing as well.
Did you try to get ownership or property records directly from Mr. Blevins?
We asked him for applicable paperwork when we visited him in April, and then we also asked him to submit paperwork in relation to that when he applied for his CCN.
And what did you get from Mr. Blevins?
Not much. We received some, but again, it only appeared to us that he owned about maybe a quarter of the wells that he was charging for service from.
And as far as you know, this is what the official land records show,
As far as I can tell, yes.
and official tax records.
Uh-huh.
Now, Ms. Johnson from the DNR testified to what it means to be a public water system under DNR regulations. So your understanding that there's just there's the 3 public water systems under DNR regulations. Those are the only ones you know of?
Yes.
And are those different than the systems that are not designated as public water systems by DNR?
That's a DNR determination. As far as the PSC is concerned, for all of his wells, he is charging people for service. And I guess if I were to put a number on it, about half of our complaints have come from the DNR regulated systems, about half have come from the other ones.
So the ones that are not regulated by DNR, those wells can provide water to residential homes?
Yes.
And you found that that was the case in your investigation?
Yes.
Now, if Mr. Blevins' well systems were regulated by the PSC, what kind of would they get any different treatment than what DNR? That DNR does? I mean, I would assume that there's a difference in the type of treatment and the type of regulation that the PSC and DNR have.
The PSC would probably see the situation as being the same across the board. If he's charging customers for water, then the source or the amount of connections is less relevant than the fact that he is charging customers for water.
And what kind of regulation or what kind of oversight would the PSC have over these systems that DNR doesn't, perhaps?
We would monitor the safety and adequacy of his service.
Do you monitor anything about what he charges?
Yes.
What's DNR doesn't have anything to do with how much he's charging
That's correct.
customers, but the PSC would.
That's correct.
Can you explain? Can you explain that to the commission?
When a company wants a rate increase, for example, it must be approved by us. They come in, they submit all of their documents. Our auditors determine what it costs them to supply people with water in this case, and at the end of that case, there is a settled upon rate. In this situation, the customers don't really have any representation.
Do you know if there was any kind of audit done or by PSC or by Mr. Blevins about what his rates should be or are?
As far as I know, no.
And the PSC wouldn't have done an audit at this point, would they?
Well, Mr. Blevins is not a regulated utility at this point.
Okay. And so until he's regulated, the PSC wouldn't have done a deep audit on his records, right?
That's correct.
Did you ask for his records?
Yes.
And what did, what, if anything, did you get from Mr. Blevins when you asked about his records?
He's given us some documents. Again, some customer lists. Some of these documents you see here. Agreements to furnish water, things like that.
Okay. Did you have a chance to look at his record keeping?
Somewhat.
What did you see? What did you observe?
Still mostly paperwork. No digital records. But as Mr. Gately said, that's something we see elsewhere as well.
And did you look to see, or did you ask him about how he handles complaints that come into him, to his companies?
We've asked him, yes.
And what did you find out?
Customers contact him directly. Sometimes they get an answer, sometimes they don't.
And is that something that concerns the PSC?
Yes.
Why would that be?
We would like for service providers to be attentive.
And was this showing that, what was his way of responding to the complaints? How would you describe that?
It just depends on the situation. There were probably times when it was adequate. There were, I've heard of several times when it was not, when people would go for days at a time without water, or I've had customers tell me that they continuously try to contact him with no response.
And how do they try to contact him, do you know?
Usually directly by phone, whether that be phone call or a text message.
And last exhibit, I'm going to hand you, Mr. Mark, to Exhibit 18. And do you know what can you explain what that document is, what those documents are? Do you recognize them?
I do.
And what are they?
The first 2 pages are just general information from Mr. Blevins, which wells he operates and how many connections they have.
Was this his response to the data requests that were sent out in the cases
I believe
that we
so.
have going? Okay. And your understanding is, was this, how many sets of data requests did we send out, or did staff send out? Do you remember?
That was a long time ago. I don't recall the exact number.
Okay. But there were more than just this set of data requests?
I believe so, yes.
But this was the first set of data requests that was sent out to Mr. Blevins, correct?
Correct.
And just generally, what was staff asking for? What kind of information was staff asking for in these data requests?
To further expand on what we see here, a list of wells that Mr. Blevins operates, a list of people he supplies water to, that he charges for water, the rates he charges, sort of operational procedure information, who his operator is. I see the name here, things like that. Things that we typically would request to know from a water company.
Okay. If I could just have a moment?
Yes.
Just to get-
Sorry, I was looking at the exhibit.
Okay. Do you recall when these were sent out? Approximately.
It would have likely been in the spring or summer of 2023.
And just to make the exhibit complete, what you have in front of you are Mr. Blevins' answers to the DRs?
That would be a correct way to describe them, yes.
Okay. I can provide the actual DR questions. I've got that document as well. I'll add that to this exhibit. I just need to make copies of it for everybody.
Okay, thank you. I think that would be appropriate.
And compared to the questions that you would ask another small utility, how do these questions compare? Are they similar, different? I mean, were they specific?
I would say they were similar, if not simplified slightly, to maybe benefit Mr. Blevins a little bit.
And so these are information that you would want from any small utility?
Yes,
Would you expect that, did you expect Mr. Blevins to be able to answer all these questions?
I do not know.
Would you expect a small utility to be able to answer these questions or get information that's requested?
In order to run a water utility business, yes.
Okay. And did he answer all the questions that were asked?
Not all of them.
Which ones, were there certain ones that stood out to you that he didn't respond to, or?
I do not recall.
Okay. But you understand, okay, never mind. I asked that, I'll move that exhibit 18.
And you're going to be supplementing that, you said,
Yes.
with the... and
With
has-
with the questions.
Mr. Blevins, do you have any objection to admitting Exhibit 18, which are your responses to staff's
No
data
object-
requests?
No objection.
And do you have any objection to supplementing that with the questions that these are responsive to?
Is that it?
Yeah, I just need, these are the questions that were.
Oh, yeah. No objection.
Okay, Exhibit 18, Blevins' response to PSC staff DRs and the DRs are admitted onto the hearing record.
And finally, you were here as part of the receivership case, weren't you?
Yes,
And you were at the hearing that was held in the receivership
yes.
action, I'm sorry, in the receivership action. Okay, I'm sorry. And you testified at the hearing regarding the receivership action?
Yes,
And you were cross-examined by Mr. Blevins?
I was.
And you and your attorney entered evidence in support of a request for receivership?
Yes.
At this point, I'd ask that Mr. Stamp's testimony in case WO 2024-0036 be entered into evidence in this case as Exhibit 19. Specifically, his testimony can be found on pages 25 to 123 of Volume 2 of the transcript.
Mr. Blevins, do you have any objection to taking official notice of Mr. Stamp's testimony from WO 2024-0036, which was the receivership case in which he testified and you cross-examined him?
No objection.
Commission will take official notice of Mr. Stamp's testimony in WO 2024-0036.
Okay, and I think the other testimony might have been entered, those all entered as exhibits.
Thank you.
I think we have, so I think I'd want this to be as an exhibit.
You'd prefer this as an exhibit?
Yes.
I'm assuming, Mr. Blevins, it doesn't make a difference to you whether it's an exhibit or whether I take official notice of it.
No.
Okay, so we'll call this Exhibit 19.
Okay, thank you.
And Exhibit 19 will be admitted onto the hearing record.
I don't have any other questions right now.
Mr. Blevins, would you like to do, it is now just after 12:30, it's 12:37. Would you like to ask your questions of Mr. Stamp now, or would you like to break for lunch?
I can probably go ahead and ask if it's okay.
That's
and
absolutely fine.
I'll try to make it short.
You don't have to make it short. I wanted to give you the preference of whether you wanted to do it now or take a lunch break, but you are under no obligation to keep it short.
What time is it, sir?
It is 12:37.
I guess we should take a break then.
It's entirely up to you. If you would like to go ahead and ask your questions while they're fresh in your head, I'm more than happy to do that.
Okay, we'll go ahead and do that.
Okay?
Thank you. Mr. Stamp, I don't know, I've got several notes here that I wrote down, but again, I see a lot of negative in there, and it looks like a lot of it is not particularly proofed out. Do you have proof or documentation for some of these weekly basis of complaints, for example, in your comments?
We've seen several on paper here. Otherwise, I get weekly phone calls from your customers. And as far as official documentation, there are the several quality tests that your wells have failed over the last 18 months. Or the fact.
Is that the complaint from the customer?
If you could let the witness
I
answer.
didn't mean to interrupt you.
I'll sustain the objection. Please allow your witness to answer, although I understood that he was going on a different course than the question you were asking.
Right.
Okay, I'm sorry. Could you clarify?
He's just asking about documentation of the complaints, not water testing or anything like that.
Okay. Currently, I typically receive complaints from your customers in phone calls and emails.
How do you account for those calls? You say weekly. 1 call, 10 calls, 25 calls, and how do you treat that or account for them?
There's no official record.
No official record?
No. In my opinion, 1 week it might be 1, the next week it might be 5.
Do you share that complaint with myself, for example, since maybe the complaint is against me?
Well, sir, I've felt that we are past that point as problems have been ongoing, and most of the time you failed to rectify them.
Did you share them with me?
Which ones?
The complaints that you claim that you receive weekly?
Some we have before. The last couple of weeks, probably not, no.
What are the some that you say you did before? not who, but I don't recall receiving any complaints from you or your company or your,
Well, I would
Yeah.
say customer complaints are the reason why we're here today.
so you don't keep a log or anything, is that correct?
There are a log of complaints here, because of how unhappy the customers are and how numerous the complaints have been. They've gotten to the point where they a lot of times just contact me directly through phone calls and email. And a phone call, for example, I guess would have no official record that we could look back on.
But you mention those as though it's something that you take action on. Is that the right way to do that, or is it just your opinion, maybe?
Could you clarify what you mean by that?
Is it your opinion that you not share these current, if there is current complaints with me? Is that your opinion, that not do that?
Mr. Blevins, with all due respect, I've found in the past that maybe could not fully trust things that have been said.
Things you say you could not fully trust, things that have been said. What has been said that you do not trust?
That customers would claim that there's a situation going on and you would claim otherwise.
What situation are we talking about that I claimed that it did or did not do, or what the customer claimed? Is there a situation that can be addressed?
Well, there have been several in the last 18 months. For example, on Rowden a few months ago when the well was shut down because apparently you didn't pay the electricity bill for it.
Did you contact me in that respect, for that particular complaint?
No, the customers had to contact the electric company and tell them it was an emergency and get it turned back on themselves.
That, okay, well, let's see here. You mentioned something about records of ownership in 20. What were you referring to there?
Could you be more clear on what it is that you're referring to, sir?
Well, I'm referring to your comment of saying that 20 records of well ownership.
Yeah, that's when we spoke in April and you gave me a list of the wells you were operating. I think it was around 20, roughly.
Okay. And in reference to Rejoice, what information did you get that I guess you indicated that I did or did not own that particular well up there?
Yes, sir. So when DNR came to us about this situation, they told us that some of the customers on Rejoice had complained. Then at the meeting we held in June where I spoke to you, I asked you if you operated that system because I noticed that it was not included in your customer logs. If you remember right, you claimed to me that you did not. And I since see that you own that well on that system.
How did you determine that I owned that well on that system?
That's what Pulaski County records show.
They did?
They currently do, yes, sir.
Yeah. Was that by a deed, or what was that by?
I assume so, sir. My search was of property records through their GIS maps, and it shows that you and your wife are owners of the well there.
Okay. You also made comments that you did not believe the records that I gave you in reference to how many customers I had. Can you tell me about that, what you meant there? I think I heard a figure of like 300 customers. Is that correct? Where did you get that information, if it is?
I think in the documents that you shared with us, I saw the number 85 connections. And I am fairly sure that you were operating more than that. If you go off the number 85 connections and figure, 3.5 people per household, then it gets close to 300 people.
That figure, more accurately, I think, would be 2.5 by the DNR. But if that's what you're referring to, that's not the connections.
Okay, well, in the
Would you
paperwork
agree
that you
with that?
submitted to us, that's what it says.
They, let's see. You indicated that some of the wells didn't have roofs on them. Can you explain which well you're talking about to me, or?
Yes, sir.
Yeah.
When I initially started looking at these wells, the Tigger well that was eventually taken over by the HOA had no roof on it. The same with the Taylor well, although it had been inoperable for 4 years by that point.
The Taylor well being inoperative, was that just recently that you said there was no roof, or is this in the past when it's non-operational?
That was in the past. You've since fixed the roof.
Yeah. Okay. It was in the past then.
But it was also inoperable for 5 years.
When did it go inoperable?
According to customers in 2019.
And okay. When you indicate that I had no concerns about the customers or the wells or whatever, what did you mean there? That, and how did you determine that I have no concerns?
Customers have shared with me their opinions that you do not respond in a timely manner to problems that they're experiencing.
Lack of available water, you used those comments. What did you mean there?
I don't recall saying a lack of available water, sir. If you could explain to me where I said it, I'd be happy to.
I'm not sure what you said. To tell you the truth,
Okay.
that what I didn't know and why I was asking you what you meant by the lack of available water. Days without comment or days without water as a comment that you did. Is there a specific time that there was water not available for a number of days, or
Well,
when would that be?
similar to what the witness we listened to yesterday, that's a customer of yours, a lot of your customers have told me of situations where they went days at a time without water. I think a lot of them at this point just expect to not have water on the colder days of the year because the systems constantly freeze. Otherwise, there were customers without water because you may have been working on the lines or whatever. But for long periods of time, that's been something that I've found throughout my discussions with your customers, is that long periods of time without water is common.
Did you investigate any of those long periods of time comments that you got from customers, or did you just simply believe what they said?
It would be their word against yours.
And so how did you interpret that then? Their word against mine. I never had a word to say that I'm aware of. I've never been notified of these long days without water.
As best as I possibly could in that situation, given that there are not meters or any way to measure certain amounts of time.
I'm not sure I understood what you said.
It's their claim against yours, and I investigate that as best that I possibly can. Obviously, there are not water meters to measure whether they were using water or not. I just know that it has been a very common theme with people who pay you for water, is that they all say they go long periods of time without service.
I'm not aware of those long periods of time. Have you got some other proof that shows these long periods of time and what that long period of time is? Is it an hour, or is it 3 days or 2 days, or what is the circumstances?
I've heard of multiple situations from multiple customers, and so I'm sure that would vary.
So you just believed what they said at that time? Is that the extent of your investigation to that particular comment that is being charged against me?
So it's this customer's claim against your claim, I guess would be a good way to say it. And I know that the volume of those complaints and similar complaints from your customer base is very high.
Yeah, okay, well, all right. Mr. Stamp, I'm looking at this photograph here. It appears, do you know what well that is?
I'm not certain. I think it's the Tigger well.
Has it been corrected?
I do not know.
Do you know who owns this well?
I believe that is the well that is now, as of a few months ago, operated by the HOA. But at the time of that picture, it was being managed by you.
The other wells back here,
Yes, sir.
do you know what wells those are?
I believe I do.
Where would that be?
I believe those are from the charity system, sir.
Charity system?
I
You say-
believe.
Has it been repaired?
I do not know.
You don't know? Who owns these wells?
I'm not sure.
Okay.
As well ownership has been really difficult to determine for a lot of your wells, sir.
Okay. Okay, Mr. Stamps, thank you. I have no further questions for you.
Any commission questions? I've just got a few for you, Mr. Stamp, and they'll be relatively quick. And, in regard to, you said that he cleaned up a few things at the well houses after DNR and PSC became involved. Can you be a little bit more specific with what he cleaned up?
Yes, sir. I guess the best example would be the Taylor well that was failed for 5 years and had trash and parts laying around it, and the roof was off of the well house. It is currently back in operation.
When was the last time you performed a site visit on any of Mr. Blevins' wells he operates?
2 weeks ago.
And do you know what wells you visited?
I visited wells on the Rowden system and wells on the Charity system and wells on the Misty Mountain system.
And when you get these calls from customers, are they complaint calls in the manner that they would be if you were making a complaint with the PSC, either informally or formally? Are these people calling you directly, not lodging a formal or an informal complaint with the PSC? They're calling you directly, and is it because they have your contact information?
That's correct.
And that's because you visited with them before?
Yes, sir.
Is there a way, or how would you investigate a claim of an outage that has occurred in the past?
Since this is fairly recent, it's ongoing, but we are in the process of talking to the power company to see how long Mr. Blevins' wells were shut down due to him not paying the electricity bill.
So if you have something external you can link it to,
Yes, sir.
then you can investigate.
Yes, otherwise we're going off of what customers tell us.
Okay, those are all the questions I have. Mr. Blevins, do you have any questions based upon my questions?
No questions.
Any redirect from staff?
Yes, just have a few questions. When you get these calls from the residents or the consumers, you said there's no official record, but do you take notes? Do you record that somehow in your own investigation?
Roughly, yes. The high volume of consistent calls, I probably don't write something down for every single one because, again, it's weekly at this point.
And do you get, besides calls, do you get other forms of, do you get information in other forms of communication, like email, text, anything like that?
Everything.
And do you take note of those somehow?
The emails obviously can be recorded. Yeah, I do jot down notes when applicable.
And do you share that information with anyone else?
I typically send it to Mr. Gately and our attorneys.
And so, even though some of the complaints aren't formal complaints that are lodged to the Consumer Services Department, you're still considering those complaints or notices of
Yes.
problems that
Yes.
consumers are having? Okay. And the ownership information that you have, that's just based on the county records that you were able to get?
Correct.
Okay, so you're just, okay, I'm sorry. And how did you, you discussed an electric system shut off. How did you learn about that?
Customers.
And what specifically did you find out about that? Anything?
That the water supply was, the power to the water supply was cut due to non-payment.
Do you know how, was that water supply ever put back on, I guess, or ever reconnected?
The customers phoned the power company and told them that it was an emergency, and the power company fortunately returned service.
And is that a concern for staff that the electricity to some of these wells has been shut off before?
Staff is concerned that anytime customers go without water.
Did it concern you that the apparent reason for the electric shut off was that Mr. Blevins had not paid his bills?
Yes.
And can you explain can you explain that concern? Or why is that a concern?
It demonstrates that Mr. Blevins may not have the wherewithal to operate a water utility or the resources.
Sorry about that. I don't want to discount complaints that you have heard from customers, but throughout the course of your investigation of Mr. Blevins' water system, do you think that you have seen enough on your site visits, learned enough from DNR, and from Pulaski County records to establish that you believe, one, that Mr. Blevins is operating a regulated utility?
Absolutely.
And do you also have concerns just based on, again, the site visits, things learned from DNR, things learned through county records, to make you believe that Mr. Blevins is not providing safe and adequate service?
It is my belief that if this were a regulated utility, and by our rules it should be, that we would not allow this situation to go on any further.
Okay, thank you.
Sorry, I just have one more question. You said you've recently done a site visit to a couple of I guess a few of the wells.
Correct.
What did you observe when you went?
It's good to see a well that was failed for 5 years back in operation, and that those people now have water.
You're talking about the Taylor well?
That's correct. Otherwise, no changes lately. Still just unhappy customers.
When you did your site visits most recently, were there still problems with any of the sites, wells, leaks, anything like that?
I haven't observed any new issues in the last few weeks, if that's what you're asking.
Okay. Okay. I don't have any questions.
Okay, it's now 1:04. We're going to break for lunch until 2 o'clock, and we'll go off the record. We left off with staff's witness Adam Stamp, and I believe that's your last witness. Is that correct?
Yes, it is.
And so staff rests?
Yes. I do have some documents that I was going to get to you, and there was one question I had about one of the, about whether official notice was taken of something. But
Sure. I've got a list of what I took official. I have a list of what I took official notice of.
okay. Did the petition for interim receiver, was that,
Yes, I took official notice of staff's petition in WO 2024-0036.
okay,
I took official notice of staff's recommendation in WA 2023-0418. And I took official notice of Sebastian Cloverside's testimony from that same case.
okay,
Well, from the 036 case.
all right. That was what I was not sure about. And then I have the supplement to that
I will take those now.
exhibit. I guess it's exhibit 18.
Correct, and these are the DRs?
Yes.
Thank you. Mr. Blevins, now that staff has rested, it's your opportunity to present your case. Did you want to witness on your own behalf?
Yes, I will.
Okay, if you want to go up and take a seat in the witness chair, I've already sworn you in at the beginning of this hearing, and I'll remind you that you are still under oath. Now, we've done this once before, but I'll remind you, there's no attorney asking you questions on your direct examination, so I'm just going to give you some time to tell the commission whatever you would like to tell the commission
Okay, thank you.
in regard to this case. So you may start whenever you like.
Is this on?
Yes, it is, and I can hear you.
Okay. I would like to begin, I guess, from in the beginning, I acquired these water wells, and I've ended up totally with 24 water wells. If there's question about how many water wells I owned or had control of, that number is a total of 24. When I acquired these wells, I knew that on my acquisition of them, that there was a lot of things that needed to be repaired, or these wells needed more work done to them, or upkeep, or brought up to a certain standard. The contractors that I actually got these wells from had confidence in me to do just that. And that's one of the reasons why I probably ended up with these wells in total. They're just from these particular contractors, not from just any individual that owns wells. And so they apparently had enough confidence in me to carry on what has been going on for 15 or 20 years with these wells, and I thought that exactly that's what was going on. And in fact, it was. I mean, it's very clear to me that that's what was going on. There was never any billings made out on a monthly basis for them. It was all done on basically an agreement to furnish water. These wells were built by these contractors not to avoid any rules or regulations because there was simply no water available to the subdivisions that these contractors built homes. And some of these tracts are 5 acres plus. They're rural areas. There is still no water being provided by any utility company per se from Pulaski County for these particular subdivisions. Still not provided. It's still the same. The condition of the support to customers were not the best, and contractors had desired for improvement of those when I talked with them. It was another reason why I took it over, for better management of it. There was cases with some of the accounts that had not paid water for years, not just months, years. One of them was a 5-year period. Since that time, that one has been cleared up. There was still 2, 3, maybe 4 of them that in this excess of 2 years that they're paying on. I mean, they're actively, except for a couple of them. I'm reading my notes as I go along here. If I interrupt or have a little pause in my thoughts here, I want to try to get all the information to you that I would like to portray to you anyway. The lack of testing in the past, there never was really any regular testing going on with these wells, except in the manner in which maybe one would be sold and the lender would require a particular report from these wells as to what the quality of the water was. That's when we would usually always treat that a day or two before at least, and when they did the testing, then it was basically clear. On some occasions, they did the testing before we ever treated them, and in my recollection of which ones are good or bad, and only a few would turn out bad. And when I say a few, I don't mean more than maybe 2 or 3 in my last 4 or 5 years or so that I was associated. I also maintained these wells for the contractors before I ever owned them by any means, or had control of them by any means, or whatever I had that showed that I managed them. Let's see here. The testing that when DNR came in with us on and activated these particular 3 areas as a public water system, they combined some of the wells in order for them to be able to fall under their 15-25 guideline. 15 connections, 25 users. The user number that DNR uses from all of the literature I've read and information I've received is like 2.5. So if we have 10 connections, then the number for the users would be 2.5 or 30. Is that correct? With 10 users?
I think that'd be 25.
25. Oh, yeah, 25. Yeah, that's correct. 25. So there's an example of how DNR put those together and activated the charity and the Misty Mountain at that time under that guideline. The Rolling Hills was only one well, which did have more than 15 connections. That is less today, but at that time, it was the only one that really qualified as a single well under their guidelines. So, and for when we hired Lori Jean as the system operator, she did a good job while she was there, and she contacted us. We didn't contact her, but and then DNR had a lot of things that needed to be corrected after their inspections of all these wells, and we went about doing that, maybe not on their particular timeline, but I hope I can explain maybe why that occurred at different times, not on their guideline or on their time frame or timeline. There was a lot of complications during that period of time. But back to the Lori Jean contract, or the system operator doing testing every month. That there at the present time we don't have testing, but it is my plan to maybe get some testing done for the June month. If not, it would have to start in July. And the reason why I say it's my plan is because when Lori Jean resigned as the system operator, that left that open and left me looking for another system operator. I know she gave me 30 days, but I still could not find an operator willing to come in and do the same operation, and we satisfy the DNR with an operator, a licensed operator. We searched all of the information that was given to us by DNR, even on the website. I've talked to a few of the individuals that indicated that they might be interested. The first one I talked to would have cost for just the testing more than what the income would have been on the cost of the water to the customers. So one of the public water systems would be charged $900 and some a month. The other one the same, $900 and some, and another one, the other one was about half of that, I believe, somewhere in there. That was impossible for me to do financially, to pay for somebody else's water testing when it's the customers or really the water users. They couldn't afford it either, so that was out of the question. Any other people that I talked to that had at least a DS1 was not interested, or in the beginning they said they were interested, but later said they were not. They didn't have time, it wasn't big enough, or whatever the reasons were. I didn't go into much requesting any explanation of why they didn't want to be there or do that. That was enough for me. They didn't want to do it. So finally, and I was under the impression, and I was told that I had to have this operator as a DS1 to do the testing. I couldn't tell you where that actually came from other than the people that I talked to about that, and getting advice from DNR and the Public Service Commission staff people. I assume is the only place I would have received that information. But I did learn lately, and that's just last week actually, I think it was, that I could actually take a test and become a DS1 licensed operator and satisfy that particular operator requirement. But also, I was not aware that I could have already made or done testing and turned it into a local laboratory. I still have some questions about what that local laboratory does with the testing. Do they provide it to the state laboratory, or what happens to it? But I did learn last week that I can do that. That's my plan. I can go ahead now with these wells and do testing, turn it in, and see what happens there, and still look for an operator or get myself into the DS1 program that's out of Springfield, the class program that allows somebody to become a DS1 at least. I have talked to Mr. McDaniel, I think is his name. He does have me registered for a class. The one that we thought I could get into on July the 7th was already filled up, and I cannot get into that particular class. But I am contemplating, maybe because of the unavailable contract or operator classes or operators that have a DS1 already, not available. Our searches indicate that they are not available at the present time. So there's going to be more time lapse there, but maybe I can shorten that by maybe taking the test just to see if I can pass that first test without class. I don't know if I can or not. I don't know what's in the test. The McDaniels, after talking with him, indicated that I'd probably only need about 2 days of orientation with him that would allow me to maybe pass the test. I still don't know what's in the test, so that's still up in the air, but it is my plan is to take the test or get the class, get the DS1, but in the meantime, go ahead and do the testing for the laboratories. Still have other questions that I'll probably end up calling Jackie Johnson at DNR about what to do with my other inquiries. Now, okay. With these wells, when I acquired them, as I told you before, that I knew that there was improvements that had to be done. I have, with almost every well out there, especially the bigger wells, the 3-horse and the 5-horse power wells, I have probably replaced all of the wet end of the well sites, which is the pump and the motor down in the ground, in the water, in the coppers. I've replaced those. That's a costly thing to replace. The last improvement I made with a great amount of money, what I call a great amount, was on Rolling Hills. I replaced that system out there that was in the water. It was a little over $17,000. That was replaced with a different type of pump and especially a different type of pump, one that would just ramp up rather than just have a hard jerk when it comes on and off, one that would be more easy to the whole system to last longer. So that was about $17,000. Prior to that, I'd spent probably $20,000, $30,000, $40,000 maybe already on different wells. That was the original plan, is for me to improve these wells, get it into a better maintenance type program, which I did from where I took them. At the present time, we have had expenses because of the new requirements that when DNR inspected all of these wells, they imposed more improvements on the well that hadn't been done yet. Those improvements I have now completed, I guess. I think they're all completed. As far as what DNR put on their requirements for continued repair. There's still repairs to do, like plugging wells. The topo well, for example, is required to be plugged. I agree with that. The problems that we had with topo was a problem that was in the beginning. We worked to try to find out what the real problems were. The well does need plugged. We do have a plan that's supposedly to be able to plug that well. Let me back up a little bit and say that when I did take these wells over from these contractors, one of the other things that was of pretty questionable is what condition was the actual well site in as far as easements and the distribution systems that come out of these wells. Some of these wells I've got the deed to. Some of the wells I do not have the deed to, but have a document that says they will produce the deed when it becomes necessary to do so. The topo well is one of those wells. I do not have the deed to that topo well, but from the contractor, I'm not sure that there's even a survey on it, even though I've been told that there is. I've not seen it personally. My search with the surveyors in the area that would have done those surveys at that time did not have a description for that topo well. So that topo well may fall into a category like the one up on that was taken over by the Tigger HOA. That particular well was, and the topo well, as far as describing it, is basically probably about the same condition. That doesn't mean that I didn't own that well or didn't have management of that well or being held responsible for that well, because I was, and I did take care of it up until a certain point. So the topo well is still questionable about which property is it on. I assume it's on one of the properties that the second house down on the right. But that's something I've got to discover yet, which I just hadn't got that far with that particular well. There was more priorities according to the DNR and the Public Service Commission staff with all of their requirements. So that would tell us that the topo well has still got a problem besides just being plugged. I think maybe I've got a legal problem, or there is a legal problem, not that I've got it, but I do have some responsibilities to resolve it, because that was my original agreements with these contractors, that I take care of the problems that come up with it. So in that case, the topo well needs to be researched for legal description and legality of plugging it, for one. Talking about particular wells, now let's go to a well that has been in the conversation of these proceedings, which is the Taylor well. The Taylor well. Yes, it was connected up to the Tigger well, and took just a turn of the valve to do that. And that was suffice. There was no loss of pressure there that I was ever aware of. In fact, when I did check for pressure, there was no complaints about lack of pressure, especially on that particular well, or that particular system. The Taylor well was sold. It was sold to a party that was hooked up to that well. I sold it for $12,000. In that contract for that sale, I had promised to repair that well site, and I did that, and I spent the $12,000 doing that. So that was just a giveaway well right there, but that was okay. Prior to that, I had replaced the pump on that well twice. Each one of those costs were in between $7,000 and $8,000 twice for that one well. That was out of my pocket. You can see dollars out of my pocket. I can account for dollars out of my pocket, even from my remembrance. But to continue the story or the history of the topo well, when we put it back together, it pumped water, but it was just a little bit short of what it should have pumped out of that 5-horse pump. So we asked the new owner at that time, because he was the new owner, we asked them if they wanted to see what the problem was with it, and they said yes, and so we actually pulled the well back up. And we found that in that particular pump, there was a problem. So he had a choice of repairing it, and we were going to help him do that, but he never did get that far with it. So it sat there. So I think some of the things that maybe Mr. Stamp had noticed was the pipe laying out on the ground, not on the ground, but on cribbage there, all covered up, waiting on to be put back in. It never did happen. So at a certain point in February, I think it was February the 20th, I received a deed in the mail directly to me, and that was from the person that had purchased the well. Simply received the deed, no money exchange, no asking for money or anything else. He simply sent me the deed. Now, that doesn't mean that I have to accept that deed, but I did. I just accepted it because what I did was go ahead and make arrangements with Rick Guile, who is the well technician that I use. And he went ahead and we got it back into operation by that deadline that was put on us by the Tigger HOA, which I think was June the 3rd or 6th, 5th or 6th, I'm not positive at which date that was actually turned back on, but the water was tested before we ever turned it back on. And it is operational today. It's been operating, and another issue with that particular well, I might as well go ahead and address it because I've heard testimony about it, and that's when the Tigger HOA took over that well. They indicated that they did a research and found a leak between the two wells, which was between the Tigger well and the Taylor well. DNR called me about it because apparently it was reported to them also, which is fine. So I went about to investigate the leak. I did not find a leak. So I excavated the area and left and still did not find a leak. If it was a leak, it was so small that it would not have affected pressure, and in fact it did not affect pressure, even though someone might testify that it did. To my investigation of it, there was no loss of pressure. So I left it open and let people know that I was going to leave it open to see what the surface water was going to do. It never did fill back up, so I kept it open. And I intended to keep it open until such time as the Taylor well was actually in place and operating again. But one of the neighbors, which is, they claimed that was on their property. I guess they, on their own, went up there and filled the hole back in. So that was after they had, after the Tigger HOA had apparently put in a valve from the Tigger well to the Taylor well, which meant that they could turn that valve off and there would be no water going into the Taylor or that line that they claimed was a leak. There's also a valve up on the Taylor well, which is behind it, that also closes off that particular line. So at the present time, with all of the activities that went on in reference to that particular leak, there is no water going in that line either from Taylor or from Tigger. So it is completely closed out. It's closed off. So that leak, I guess, is taken care of by whatever activity took place. Let's see now. Let me look at my notes again right quick, please. When these new expenses and the expenses that I incurred from the time that I acquired these wells until present day, I had to pay basically out of my pocket. The income that came in from the users was not sufficient to pay the improvements or the upgrades or whatever other expenses occurred. Just simply wasn't enough. Not enough money. So that may, and not may, but that was a cause of maybe some of these complaints that these people complained about having an increase in their well cost. Pretty obvious to me that, yeah, because if they had not had a increase in their well costs for 10 years, 5 years, or whatever, then all of a sudden they get an increase that's a little bit more than what they expected, then yes, they should have some concerns or ask questions, but they apparently didn't accept anything that was told to them, especially by me, because my answer to that, to all of the questions that had to do with rate increase, I tried to put in documentation mailed out to them. The agreement to furnish water also indicates in there that there is an increase in the cost of water, but not more than an annual percentage-wise. And if you took that percentage and you multiplied it times 10 years, we still haven't reached what it could have been. Right now it's $55 a month. I can tell you that any new members at the present time is new, not members, but well, they would be members now, but the new ones would be, to start with, at $60. They're new. They're not grandfathered. Otherwise, it's $55. There is a charge of $15 for a water pool, or a pool. And that's $180 a year. It costs more than $180 a year to maintain that that swimming pool with water. I can almost guarantee that. Of course, I don't have those figures, and those are estimates, but those estimates came from people that we talked to about pool owners and people that provide pools or make pools or whatever. They tell us different information about, and that's how I determine some of these costs. Not particularly some metered out water. It's not a metered situation. It never was metered. It never intended to be a profitable well for anyone, but somebody had to run it. And it ended up with me from these contractors running these wells. And it kind of surprised me, though, when I did receive a deed in the mail to the Taylor well with no explanation of it. But, and I still haven't heard from the grantor in that deed document. Still not have heard from them. That well, if that would be the case, and well, I won't go into that part of it, but let's see here. On charity, I've got to go over to the other public water system that DNR has activated. We've talked a little about Rolling Hills and Misty Mountain. Charity had one well on there that originally the Department of Natural Resources was requiring me to plug. That is probably to replace that well, just as a thought, it would be probably in the excess of $50,000. That's a heavy cost. It's a 5-horse pump, and one of the reasons why it was actually down for a period of time is that in our initial investigations with that well, or knowledge with that well, we understood that the electric company had at one time run over the wellhead and had cracked that, possibly, so that would have made a real problem. We never had any bad results of testing from it that I'm aware of or remember. But the only thing that we repaired, and we use the word repaired, actually, which it really wasn't a repair. It was just a replacement of a control box for that well, which is a 5-horse. It's $1,000 box, 800, 900. I've paid different prices for every one of them, depending on what companies I'm getting it from. But and by the way, I've probably replaced every control box on every one of these wells at one time or another in the last few years that I've had control of them. So it wasn't any new construction or anything for that well. So I felt strong about not having to plug that particular well, so I submitted information to DNR, and along with the repair billing, no, I think it was a repair billing. Well, we call it repair, just replacement of that box. The well repair from the damage that I spoke about just a few minutes ago on the wellhead had already been done. And that was done either by myself or the contractor. I don't recall who did that repair. I believe it was the contractor, but I believe I was asked to do the repair. I don't recall that. As I said before, I used to work for these contractors, especially taking care of some of the maintenance on whatever they needed. Also, in the past now, I was partners with one of the contractors, building contractors, who is a large company. He's kind of retired or trying to retire like I am at the present time. I'm a little older than he is, but he still wants to retire. Don't blame him for that. So I'd like to give you a rundown, just a little bit, on connections and plans. What I want to complete and do with these wells. I've heard a lot of testimony back and forth, and it appears to me that the testimonies and the information that's being testified is in the beginning. They're talking about so many wells, and as progress goes on, we've reduced the number of wells. So what applied maybe back in that particular time that they testify for is not what it is today. It has changed from where it began to where it is today. And to tell you the truth, there's been a lot of changes done from the time that, let's go back to Department of Natural Resources when their first visit and they activated these wells. There's been a lot of activity. A lot of it I've had to do on my own, basically, I guess you might say, or trying to fulfill their requirements and also trying to fill requirements of the Public Service Commission. It was, at best, almost impossible. Or difficult. Let me say that at best it was difficult to do. And it's still primarily difficult to do and meet with their time frames still being jumped up here, or their time frame's still being enforced. It's okay, but I'd like to explain just a little bit later about why there is maybe delays that are evident in there. Let me go back to the 3 public water systems that was activated by DNR and what my current plans are if I'm allowed to complete these plans. That I'd like to know that, you know, so I'm not wasting somebody's time or mine. And let's start with Charity. There's 3 wells on Charity at the present time. There's one of the connections, one of the wells I'm going to call MW16, which is the number 2 well identified by Department of Natural Resources, have 7 connections. MW17, that is identified as number 4 by Department of Natural Resources, has 4 connections. MW18, which is identified by Department of Natural Resources, I believe is number 3, has 11 connections. For that Charity, now Department of Natural Resources has another well, which is MW15, they call number 1. That well was previously sold to a party that is on the well, and that particular well is one that Mr. Stamp had provided pictures for, that I don't think he knew what the current condition of it was, but that was sold a few months back. It's no longer in my possession by any means. And that was one that did not have a described a description. So in order for me to correct that, as I had promised contractors, I would have had to make a description myself, which I'm capable of doing that, or I would have to hire a surveyor to come out and actually make a brand new survey based on the information that's available to the surveyor. But we didn't have to do that because the person that bought it, that well was already on their property. So we had a document that sufficed for that, and we passed that on over to them. So we have 22 connections, not 26. DNR still had it all as 26, but they weren't up to date with the information. And maybe that's my fault that they don't have the current information, even though I thought I'd given it to them sometime back. And maybe it didn't get into their records or to their satisfaction as to believing what I told them actually took place, or that well is no longer in the Charity system, as they call it. I had no control over it when it was sold after that. So 22 connections is what is presently with the Charity public water system. That gives them 33 consumers or household, 33 individuals. So that qualifies when you put all 3 of those together to be under their 1525 requirement. But when you separate that, they don't qualify. So I do have a person that we are pending a sale to for the MW16, which is the number 2 well by DNR. I also have a person that is interested in purchasing the MW17, which is the number 4 by DNR, and also a person that is interested in the MW 1811 connections. Have a person interested in that one. Those 3 wells we hope to get sold here in the very near future. When that happens, the DNR tells me that then the public water system would no longer exist. They can't be sold to the same person because that puts them in the same position that I'm in at the present time. So, but there are individual inquiries about that. So that's the plan there, is to, in the meantime, I'm going to do everything I can to stay up to date with the Department of Natural Resources as far as their particular agreement is, their OAs, or I forget what you call them actually, their agreement for me and my wife to sign off on and give the Department of Natural Resources an agreement of sorts that we can operate and use to apply for this permit to issue water. The Misty Mountain, if we can go there, again, I'd like to break it down for you. There are 16 connections at the present time on Misty Mountain. MW04 would be DNR's number 2 well, I think, on Tigger. There are 6 connections. And MW03 is the Taylor well, which I don't know what number DNR refers to it as other than Taylor. So that's the Taylor well. Now, there is a buyer for the Taylor well. I will be selling it to them when they get off vacation. That's 5 connections. The MW05, there is no well on MW05 because that's the topo location. And on that topo location is the well that needs to be plugged. And it wouldn't have to be, but according to DNR, it must be plugged to prevent any suspected contamination of the coffers areas. There are 2 other wells that was dug or drilled on that same topo property, a roadway, I mean. But the MW05 or the topo well is not a well site at the present time because I have to purchase that well water from the Pulaski County Water District. I have to purchase that and then resell it to the parties. I would prefer that we have some sort of other documentation that just takes me out of that and gives that distribution of water to the individuals up that are on topo. I haven't been able to think of a document other than my plan is to go see an attorney, an abstract attorney, not a litigation type attorney, but to see an abstractor about making a document that gives them the possession for the household or for that topo project or the distribution of that or the well or the connection that was put out there several years ago, actually. And I didn't know that until we started doing our other investigations for what the real topo problem was. Apparently that problem on topo is a 15-year-old problem. possibly. But the way it was explained to me in reference to topo is that 15 or whenever that well was originally put in there, the owners, not the owners, but the property owners, the consumers of the water that was in that well, they were originally put on the public water supply district, but they didn't like it. They didn't want it. They wanted a well. So a well was put in, and that particular meter out there was just abandoned. Say abandoned, it wasn't used. So it was just there. It was available, but it was not being used by anybody there. So when I was able to find that out through investigations, continued investigations, I found that there was a meter there that was attached to the distribution system at Topo. And the contractors had originally put that line in there as a 1-inch PEX line. So we activated it, and that's where they get their water today. When I believe there was a testimony earlier in this procedure here to where one of the residents there on Topo had requested for the quality of their water. I know the person because I talked to her personally myself and explained to her where she got the water from and etc. But when they went out there and to do that testing, whoever did that took it from a different residence and was not applicable to relay that information to this person that really wanted the information. So at that point, what DNR did, or what I was told they did, was that they went back to the public water system, the Pulaski County water system, and asked them to do testing for their side of the water that would be provided to this individual, and then she would have the report from where her water source was coming from. She would have that quality of water. So my plan, the one well that was hostilely taken over, which is we called MWO1, that was taken over by the Tigger HOA, which is fine. It's okay. The MWO4, the one that has 6 connections, it only had 5 before, but I took myself off the MWO1 Tigger HOA because of that situation and the manner in which they did all of that. That's the only reason why I got off of it. I did not want to associate with that kind of activity. So I didn't. I simply connected myself to the other well. That well I will want to keep. I would want to keep that well because I'm on it personally. And there are 5 other individuals that's on that well. Individually by itself does not qualify to be a 525 well governed by Department of Natural Resources. Right now there's 16 connections when you add all of those up. But it would go down to only 6 connections when I can get a different document for the distribution of water from the Pulaski County Pulaski County Water District, that they can just make payment directly to the public water and eliminate me out of that picture for that well site or that that topo situation. And number 3 would be the sale of that Taylor well, which would go away out of the public water system with DNR. So that would only leave 6 connections, and I'd want to keep it. And that particular one, I don't have the deed yet. I would have to further describe it or hire a surveyor to come in and survey that out and then request the deed for that. And that's probably what I would end up doing, or I may just leave it the way it is. It doesn't make me any difference. But the contractor may want me to correct that as originally agreed to. So I don't know about that legal part of it there yet. Now, so that would eliminate Misty Mountain. At that point, my plan would be to not have but one public water system left with the DNR, which would be Rolling Hills. At the present time, there are 16 connections. To update on Rolling Hills, one of the residences have already drilled another well, so that eliminated a connection from the 18 connections, I guess, might have been the last report. And also that one of the residents have purchased the property next to them and with no connection, so that was a connection that was available, which would also reduce the number. So it's 16 connections at the present time. So 16 connections, I guess, would give you what, yeah, okay. So Rolling Hills at the present time would be the only one left, which we have already signed agreements with the Department of Natural Resources, but there are still some conditions that I have to meet. I'd have to review them again to make sure I understand what those conditions are and how I go about it. Now, at the present, I'm still dealing with timelines and other regulations going into the registration of the public water systems with the state of Missouri. I have initiated the certificate. I do have a certificate of incorporation for each one of the public water systems, which is Charity, Misty Mountain, and Rolling Hills. I also have the articles of incorporation. I may not have supplied that to the DNR, but I intend to do that. I also have the bylaws. And I may not have provided that to the DNR. I thought simply that maybe I think DNR has verified that there are incorporations or HOAs registered with the state of Missouri. The declaration of the public water system well agreement, which is an agreement for restrictions and covenants in reference to the HOA. The HOA is a nonprofit, and at the present time, I've got the documentations for everything I think is needed for the registrations and should satisfy Department of Natural Resources and maybe the Public Service Commission should be satisfied as a nonprofit organization and not a utility. Now, because of the time frame, I made those registrations with the state of Missouri because it's got to be an ongoing process to get to the end of what this is going to look like at the end as an acceptable to all of the people that are out there using this water and becoming a part of this homeowners association. I found out that the people I've talked to have sour notes and sour thoughts about homeowner associations, I guess from prior experiences from what I've been told. If one is conducted properly, it should be good. But on charity, for example, I have two individuals that have simply, let me back up just a little bit and explain how I initiated this homeowners association and registered with the state to get it started and meet the timelines for the DNR. Is I sent out a letter to all of the users, the consumers of this water from the well, and outlined to them what I was needing to do or what was needing to be done. I had no intentions of ramrodding everything, but somebody had to start it. Somebody had to do something to satisfy the DNR requirements. So this is what I did. I wrote that letter, and I explained in that letter how they could, how we could activate into an HOA as a nonprofit rather than a profit or a utility type company, which was never intended. In charity, I have letters that indicated two people said no, they did not want to be a member to an HOA. I have one person there besides myself that paid to be a member. One person paid a discount because I offered in that letter a discount for them to become a member. And that, and then 19 on a pay schedule at the present time. And the reason why I say a pay schedule is that in that letter, I don't know if it was clear or not, but at the present time, they pay $55 a month. I'm not trying to, I did not try to shove this HOA down their throat, so to speak, I've heard some testimony, I think, that I was just doing something on my own. I'm really not doing it on my own. It's being done, promulgated by the Department of Natural Resources and the Public Service Commission, in my opinion. This is where they're sending me by their their probing or their investigations that I don't find very, well, I find it lackadaisical, to tell you the truth. That's what I find the investigations, and it's not their particular fault, in my opinion. It's just they're getting wrong information, and they're not tying down the right information, in my opinion. But, so in charity, I offered payments for the $3,000 membership. That $3,000 also tied up to what the cost of that well is to them as a member. So at the end of that particular time, and in other words, I'm taking their $55, and for the next maximum of 10 years, part of that is going to be to the purchase of the well. And then I'm done, I'm out, I'm done. But I did offer that a discount payment, which is like a $900 discount, which I had In charity, I had one pay that. If anything changes in the meantime, that's still going to be accounted for as their money that they've paid into whatever we get discovered here with the HOA. So I gave them a way to become the HOA and pay for it. The person that paid this discount pays $25 a month, because that's what I estimated that maybe the HOA would want to continue to pay or collect $25 a month if they after the acquisition of the well. So that $3,000 that I put out there is the cost of the well, with however many connections that were done at that particular time. It doesn't mean that it could be adjusted from time to time if we lose connections. So that's on charity. Now on Misty Mountain, there's one paid on Misty Mountain, but really not paid, but it was credited. But Misty Mountain is also, let me back up. Misty Mountain, and they're all on payment basically except for one, and that was a credit. So that's just a regular payment, but after so many years or so much payment at $3,000 per hookup. Now this is if we don't sell these wells. If we sell these wells, then that's a different story. We're going to eliminate the HOA. So I don't want to be complicated information here. It's simply a change if we sell the wells. The Rolling Hills, there are 6 of the individuals out there that said no to the HOA. They didn't want to be part of it. And one paid a discount. So there's basically 9 on payment, on a payment schedule. If that ever changes, the money is still accounted for their credit or what they paid. But I assume that Rolling Hills is going to continue as a HOA, where Charity and Misty Mountain may not. That depends on the sale of those wells, which even though they're scheduled to be sold and I've got buyers for them, I still have to have this plan for the DNR because of their timelines. I still have to do that. So what do I do first? Second or third? And then I've got the push from Public Service Commission right behind all of that. And so I'm left with decision making as to what I do next. Even what I do next probably changes from day to day. But when I mentioned earlier that it's difficult at best for me to meet these scheduled deadlines. And I'm telling you, it is still difficult to meet. One of the reasons, not the only, is the fact that my wife and I are elderly, I guess you call us. I'm 80 years old. My wife is 78 years old. I have medical conditions, heart conditions, artificial arteries. I've got medical conditions. I don't need to tell you exactly what's wrong with me. But that takes time for me to take care of. But what additionally takes time for me to take care of is my wife. She is a cancer survivor, and has no immune system. I have to feed her myself daily. And I feed her through a G-tube, and sometimes, I don't know if you know what a G-tube is, but that's a syringe that pumps medicine and food into her body. She does still get out and speak and etc., but not very well. She had throat cancer which really destroyed her system. So in reference to time and trying to meet deadlines, there's a priority for me to meet a deadline with my wife, my spouse, and my doctors. So that takes up time. I'm not saying it takes all of my time, but it does take a good portion of my time to do. I had to, in my business, what I do, I retired in 1981 from the military, veteran. But I've done all kinds of other business. I continue to do business, not just water wells. Water wells was never a business as it started because it was something that still had to be done, and it was a fiduciary agreement that I basically had with contractors and partners that I had been in business with. Construction. We built houses. We did all kinds of subcontracting, roofing, drywall, construction. I had to quit construction because I was physically not able to do that. When I had to quit that, where I was paying $10,000 a month in expenses, and I had to quit my business of construction, I wasn't making $10,000, but some of my expenses I still had, and I still have a few of those, but not very many left. I can handle those. But that was a change. It was a change. I had to quit to take care of myself and my wife and other businesses. My wife did have and still does, an antique type business in a shop that we've got. I had another salvage business that I still do, but I'm trying to get rid of that too. I've got to get rid of all of my business and actually be able to spend more time with my spouse. I've been married for 62 and a half years. I've been with her for 66 plus years. So that's a priority for me. It always has been, as family or whatever. Those are some of the reasons that I've got that maybe I don't get to your timelines in the Department of Natural Resources menu or the Public Service Commission menus that they send to me. I just simply don't have time, but I don't want to make excuses to you either, and I'm not going to. I'm just telling you what my problems are, and you can decide what you're going to do with me, I guess. So that's what my wife does. She decides what I do. All right. I could not afford an attorney to represent me or this water wells in reference to the CCN application and the Public Service Commission. The first quote I had was a retainer of $20,000. Unreasonable for me. The wells didn't produce anything close to that for even on a yearly basis. And I've heard testimony about they don't, some of the information that gets to the Public Service Commission and the DNR is not correct. I don't know where you're getting your information from, but it is incorrect when you're talking about 300 connections on a water well, and even incorrect when you're talking about 100. There's barely, I don't remember having any more than 90-some connections, and that was in the beginning of what I would have with 24 wells. As I just went over, I don't have 24 wells left. One of the things, and we have 54 wells, I guess. 54 wells with what I just went over in the Charity, Misty Mountain, and Rolling Hills. 54 connections. So from 100 down to 54, we've had activity that has reduced these wells 50%. Would that be about right? I think. My way of mathematics, it is. So the improvements that has been done with these wells, all these wells are operating today, and they're operating at a better condition than they were before. And I will give Department of Natural Resources credit for some of that, because they had more requirements for me to do that I think I fulfilled. Not every single one of them, especially when you're talking about plugging a well. I haven't met that yet. But there are complications in that, as I mentioned. I need to know the legal owner of that well at the present time before I can correct that and do something on my own and not be liable. Or unless Department of Natural Resources wants to be liable. I don't think they do. So I should protect that also. So can I meet that particular well requirement? I think it's already passed. I believe I heard testimony yesterday from Ms. Johnson that today it was the day for one of the wells to be plugged. Not going to happen. It's just impossible to do. But I have precautionary taken care of the fact that there's no backflow into that well from the well distribution system or the well house, period. I intend to provide Department of Natural Resources with all of the documentation for the registration of these public water systems that were activated. But I also intend to continue to try and resell these wells to the proper persons, not to just one individual. I may address some of the other wells that I think the Public Service Commission has asked questions about, which are wells that were not considered by DNR to be part of the public water system. There was 8 of those wells. I've since sold those wells to one person, and under an agreement, though, that still gives me, gives myself an opportunity to resell those wells in a proper manner, which I've done one of those already. So there's only 7 of those other ones. Those wells are very small wells and probably not over 2 horsepower, and service only maybe, most of them will service two connections. So Rowden is one of them, which there's 1, 2, 3, 4 wells there. They're all not over 2 horsepower, and only one of them has 3 connections. The rest of them are 2 connections, and one of them is, I believe, 2 connections. Yeah. There is a particular problem with the well on Rowden, which I call MW22. That was the 22nd well that I had acquired in my first explanation of how many wells I started with, or ended up with to distribute, or before DNR got involved and I started reducing those wells, not able to meet all the requirements. The reason for the MW22, and there's been a couple times that MW22 electric had went off, and I think maybe that's one of them that was maybe testified with by Mr. Stantz, indicating that there was the electric was off on a well site, that the MW22 well had a problem when I acquired it, but I was not told about that problem. I had to find that out for myself, and the way I found out was well, just simply doing regular maintenance and doing an inspection on the well. We discovered that there was a leak in the line about 60, 80 feet down from the pitless, if you know what that is. The pitless is an area where the water comes up and out of the, and goes into the well house. It's just a connection between the walls of the casing. But we found that there was a leak on the line, which is a plastic line. It's not the best line that you can have, but when it was constructed, that's what they used. And it's an 1.25 inch line. It's got a crack. It's split. The other problem, the first time that we went out there to pull that line and repair that leak, we couldn't do it because the where you connect onto the pitless, top of the coupling on the top of the pitless was compromised. If you used the wrong type of connection, you couldn't get the instrument that screws into it to pull that whole line up. So we had to do what we call a fish hook, and we had to manufacture that fish hook and lower it down into the casing, wrap it around the water pipe itself, connect it by its mechanisms, and the fish hook, and pull it up. That was the second time that we went out there, but it would not work. The casing was also lined, and I think Mr. Stamp would know what I mean by lined. In other words, the distance inside the casing and the lining is reduced, so it reduces the space that you can get the fish hook down in there, hooked on to the proper connection and pulled up. There wasn't enough space, so we had to go take that out. That's the second time. So we had to remake that fish hook. And we went out there one other time, but Rick Guile is now ready to go back out there with another hook, with another fish hook, and fish down in there and try to get that up so we can actually repair that line. That particular well is costing about $7 a day to operate. Now that's a 1.5 horse pump, and Mr. Stamp would probably tell you that it shouldn't take over $1 a day. Is that about right? Well, I shouldn't ask that question, I'm sorry. It probably shouldn't take over $1 a day to operate.
And we have those routing wells on a prepay program. And it's on a prepay program under this other person's name that operates it. I help them do that and to give, it's a lady that help so that they can learn what to do and so forth. So I've guaranteed my assistance to that. Those electric bills are under her name, but I usually, in instances where she may not have the right amount, I step in and pay that for her. This last time, I think it was probably the one that Mr. Stamp was alluding to, that the electric company turned it back on. It couldn't have been over an hour or two, and the only reason why it was that long is because I wasn't notified. There's supposed to be an early notification for when it gets below a certain amount of money on that billing. And my understanding is that we were not getting the right notification. I hope I've corrected that with the electric company. I don't know if I have, but at least I tried. So maybe that was the reason why. Rowden has never been out for more than an hour or two or whatever, in my opinion, that I can recall at all. When we were out there with the truck, the tire truck, I'd call them tire trucks, it's where they pull those pumps, we had to go across a party's yard. He did not want us to do that, but that is an easement area, or it's supposed to be. But so we had to find another way to get into that well, which that's just a little problem that we can solve. But in these wells, there has always been some problem that I get calls on. That's one of the reasons why I was involved with them, is because contractors had enough confidence in me to go and repair these wells or take care of the legal problem on the other end of it when it comes to describing it, who owns it, etc., whatever. I'm not, I've been in real estate for a long time. I was president of the Board of Realtors back in the 70s and 80s. I was on the Pulaski County committees that originally brought in sewer districts for that county and etc. I'm not unfamiliar with this type of construction or this type of business. Not unfamiliar with it at all. But I'd like to get away from it. See, what else? I've told you about these other wells. I still have some control over them, but I don't own them. I have a contractual agreement to provide the deed and account for them, and I intend to continue to do that until they're properly in the right place. One of the agreements I had with the contractors was if a problem could not be solved, then I should look at homeowners associations, and that's what I've done. The Public Service Commission kind of ramped that up a little quicker than probably where I would have been, because it's difficult at best to deal with their requirements. In fact, it's almost impossible for that to happen that way. That's the reason, one of the reasons why there's a HOA being made, being done. But it is a continuing process, and we intend to get those documents that are necessary to finish up the HOA, which is a document that needs to be recorded at the courthouse that says they're a member, And this is their legal description of their property that they own, and this is the well that they get that water from. That's what that document will say as a member. So it's of value. It's being paid for by their regular payment that they make now. And that started in February, is for the accountability of those funds for the HOA. I have one document that my wife actually prepared and asked me to provide to the commission. Yeah, thank you. I talked with Mrs. Kerr, and she agreed to have it entered in as review for the commission. And so they've offered their services and to even do that. That particular letter is just from my wife. It's her few words that she wanted to speak about. She couldn't be here. She can't be here. There's no way she could have even sat in here for an hour. So she wanted to do that. I promised that I would present that, and if it's okay, just mark it however you want to or what you need to.
Mr. Blevins, I'm going to mark this as Exhibit 20, and I'm going to, what would you like me to call it, the Blevins letter?
The Blevins, Pat Blevins letter,
Blevins letter?
that'd be fine.
You said Pat Blevins?
Pat Blevins, Patricia is her first name.
Okay, are there any objections to admitting Exhibit 20, Patricia Blevins' letter, onto the hearing record?
No.
I hear no objections. Exhibit 20 is admitted onto the hearing record.
At this point, I think I've covered most of the information that I would had in mind to deliver to you. Let's see. I would only ask, I guess, maybe in closing that that I be allowed or given some other consideration for more time, if that's what it takes to meet some of these obligations. I intend to convey my plans whenever they're asked for, I guess. Or to continue to try to meet, especially the DNR agreement guidelines. I still want to be able to try to do or finish up my plan of selling these wells, or get them into some other operation that I'm not responsible for, so I can go about maybe my retirement. I don't know. I don't know how to put that other than request consideration of more time to finish up what we need to do with these wells. I'm open for any questions, I guess, that.
Any cross-examination from the commission staff?
Yes. Yes. Let's see. So you admit you're charging customers for water use out of the wells, some of the wells that you own and some that you don't own?
Obviously, yes, ma'am. I charge $55 for to every one. New ones coming in, we're gonna start them at 60, because I see that more expenses. There, with the Department of Natural Resources, there's still expenses that haven't even been on the table yet, which is another $40,000, I would say, by the time I'm through with Rick Guile and trying to meet all of the Department of Natural Resources. Still got to plug a well somewhere or another. Got a fine to pay with the $6,000. I've got to do that one way or another. But yes, but that is not what's going to pay for. Well, to answer your question, yes, I do charge. I've never denied that I didn't. That was part of the responsibility of it.
But you withdrew your CCN application?
Yes, I did. I withdrew the CCN. There was no way I could, there was just simply no way I could meet those requirements of, you had 41 different requirements for me to deal with. And when I answered those, I was, from my recollection, it appeared, or I took it as I didn't know what I was doing, but I do know what I'm doing. I know that I cannot meet those, and that was not a utility company. I can't be a utility company. There's not enough money there. There's not enough income.
Okay.
It's pure and simple. That's obvious. Well, it was obvious to me, I'd say.
And some of those wells, so some of those wells that, you talked about having 54 connections with the public water system that are under DNR regulation.
I'm sorry, what?
You said something about, that you had about 54 connections
Yes.
that were with the public water system, that were systems that were.
At the present time, yes, ma'am.
Okay. But you do own other wells that you're charging for water that aren't.
Are the other two that are not part, or the other wells that are not part of the public water system?
Yes.
Yes, of
Okay.
course. That, I didn't tell you how many persons there are, but do you need to know that number? I can add it up real quick.
How many connections there are to the wells that are not?
What?
I'm sorry, did you say how many connections?
Do you need to know how many connections there are for those 8 wells?
Sure.
Or 7 wells at the present time?
Okay, so there's 7 other wells that are not under DNR
That's correct.
regulation, but that you charge money for.
That's correct. $55 a month.
And how many of connections are those?
Okay, let me do a little quick connection, or mathematic for you here. Out of those, I think there's about 14 connections.
Okay, so at least, so about 30 or so customers, or individuals, I guess. if you do
2.5, yeah.
I didn't do the math, just kind of guessed.
But those are located miles apart from each other.
Okay,
They're different locations.
okay.
And
But you're still charging for that, for the use of that water?
the what?
You're still charging them for the use of that water?
Of course, yes.
Okay. Now, you remember being here, you remember in October when we were at the hearing? And you testified?
Did I testify? Yes.
Okay. And you were cross-examined by me and Ms. Asland?
I couldn't hear you, I'm sorry.
You were cross-examined while you were on?
Yes,
Okay. I'd ask that Mr. Blevins' testimony from the WO 2024-0036 hearing be entered into evidence. I guess it'd be 21, or I could do it as my exhibit and then we'd be on 20. Or,
Well, I'm not breaking them up by staff or respondent in this case. I'm just, since it's just two parties, I'm just doing one list all the way through.
okay, so it'd be 21.
Yes.
Okay.
It'd be 21 regardless of whose exhibit it is.
Okay. And just for the record, Mr. Blevins' testimony can be found on, in volume 3 of the transcript. And on the pages. Where did I go? Pages 50 to 96 of volume 3 of the transcript. I'd ask that that be entered into evidence then.
Mr. Blevins, do you have any objections to admitting your testimony from the receivership here?
no objection.
Okay, Exhibit 21 is admitted onto the hearing record.
Okay, thank you.
Did you have further questions?
I don't think so, but let me just double check here. You were asked by staff in data requests to provide information, agreements, documentation about the homeowners associations, and if anybody's signed up for those. Have you provided that information to staff?
I just went over that in this testimony here as to what I have at the present time.
Okay, but you haven't provided any documentation yet?
No,
Okay.
no. Not to, are you talking about the Public Service Commission staff?
Yes, through the,
No, I
Yeah.
haven't.
okay.
I can if you want, but with time.
I think those DRs were sent to you back in May and were due June 10th.
I'm sorry, I couldn't get,
Those DRs were sent to you May 21st, and they were due, asking for those documents June 10th.
I think so. That was like a 20-day period or a 20-day line.
Yes, that's per regulation.
Yeah, that was almost impossible for me to meet, and the reason why is that during that period of time, my wife had 2 emergency surgeries in the hospital for over a week. I spent time with her 24/7 at the hospital. Those surgeries were subject to life, so.
Did you ask for an
I didn't really have, no, I didn't ask for an extension. I spent all of my attention with my wife.
Okay.
And I thought in my own mind that even though I didn't provide that to you, I don't think I sent you any note saying I couldn't or wouldn't, but I think I've done that today in this testimony,
Okay.
what you had asked for in those DRs.
Okay.
If not, I'll try to answer those if you want me to continue to answer them. I'd have to look at the DRs again myself.
Okay. I don't have any other questions right now.
Are there any questions from the commission? I hear none. Mr. Blevins, I have some questions for you.
Judge, I have a couple questions, if that's okay.
Commissioner Mitchell, please go ahead.
Thank you. Thank you, Mr. Blevins, for your testimony. And I think
Hold on just a second, Commissioner. Is there any way we can boost the volume? Okay. Commissioner Mitchell, Mr. Blevins is having a hard time hearing you. If you could lean a little close to your microphone or turn up your microphone's volume, that would assist him greatly.
Great. Is that any better?
Not a lot.
Hang on just a second.
Can you repeat the question for him?
I would be happy to repeat the question.
Sure.
Mr. Mitchell, if you just want to, or sorry, Commissioner Mitchell, if you just want to tell me the question, I will be happy to ask it.
Sure. What I can gather is that Mr. Blevins' kind of overall strategy was kind of going through each well site one by one is to kind of disaggregate the ownership of the wells either by selling them off or putting them in possession of a homeowners association. Is that true? Do I understand that correctly?
Yeah, I see where you're going with that. Let me ask that question. Mr. Blevins, what the commissioner is asking is is essentially your plan, given that DNR is requiring 15 connections or 25 people, is your plan, at least in regard to DNR, to disaggregate this system by separating the wells out among different owners such that the DNR regulations do not apply?
No, that's not the entire reasoning. That's what would happen if those were separated. And in fact, they were originally separated and still are separated. What put them together was DNR. DNR is the one that in my thinking has caused that particular problem to exist with the 15 connections. Individually, they don't qualify. The other part of the separating them is that they are, it doesn't cost as much to the consumer to operate that well when they're just operating for their use, period. Their smaller use, like instead of 22 connections like in Charity, each one of those is going to be reduced down to a much lower connection. Going to be 3 different areas with one well, and the cost of that to the consumer would be way less, maybe even half. There's no cost, there's a big cost in trying to meet all of the requirements of the Department of Natural Resources, even at the present time. Per month, $55 may not even be enough to handle what would come down now if all of them are kept together and in a public water system. I understand that one of the people that was interested in buying just their wells, where they get the water. In other words, if you can picture this again, 3 wells in the Charity system is originally connected to 7, 4, and 11. That can be reduced to almost no cost to the consumer. The person that is getting the water or paying for the water now at $55 a month. Maybe that can go down to 25 or 30. Get that back down there where they're more comfortable with it, because they're only having to deal with a smaller number of connections with less rules. They can still do testing. They can still do that, even at the public laboratory, at the water well, or the water laboratory, the county health department, basically. You can do that for $15 a month, period. Not 150 or 200 or 900 like one was quoted to me.
Does that answer your question, Commissioner Mitchell?
It does, and I'm also curious how, I see how that disaggregation could, streamline the regulatory compliance. But in your viewpoint, is that that strategy of sale or disaggregating the ownership, how does that help meet water quality standards? As I understand it, several of the subsystems are having trouble meeting the water quality standard for E. coli, and I guess just because the DNR wouldn't regulate a small system or a system that's smaller than 15 connections, that doesn't change the situation that there's still some well sites that the contamination needs to be dealt with. So how does distributing the ownership to get under DNR's threshold resolve the water quality issue?
Commissioner's question is, how does separating the ownership of the wells into small enough parcels to not be regulated by DNR, how does that improve water quality? Or how does that address the problem with the water quality, I think is more specific.
Well, the address to their water quality, even at the present time, is the lack of testing. And so they can still test. And that would be even the HOA's choice.
Okay, so your answer is then that's their responsibility as the well owner at that point.
Right, it would be their responsibility to test the water, and they can do so at a much lower cost to the consumer. But I would guess that particular fee would be about $15. That's what I paid before with the public health department and their laboratory report for water of E. coli or bacterial.
Are you saying that would be cheaper to get it tested locally than to send it to DNR?
Yes, sure. That would eliminate $300 a year for bottles, I guess. I don't know. Only in this case, it's $900.
Did you have any follow-up questions, Commissioner?
Just one. As you envision your plan for the system going forward, I think what I understood is that you would still have at least one system where you would continue to own and operate the system and sell water to other customers. Is that correct?
The commissioner's asking, if you'll remember, you said you disconnected your house from the Tigger 1 well and connected it to another well, and you indicated that you would like to retain that well. Is it your intention in retaining that well to continue to sell water from that well to other people that are connected to that well?
Well, it would be at a lesser cost. There would be 6 people on that well. That would be me plus 5 others households right there on Tigger. It would be even then a reduced cost.
And so the answer would be, yes, it's your intention to still sell water from that well.
Yeah, they would still, each residence would have a cost to pay for the water, including myself.
Okay, would that be through you running it as a business, or would that be through you as a member of an HOA?
That would be me, not particularly me, but I would probably organize some other type of group with the other owners, because it's just simply a well that we all get water from. We have an electric bill to pay. Somebody's got to pay for that electric. The repairs, somebody's got to pay for the repairs. Somebody has to do the maintenance on it. So someone has to do that. I'm willing to do that with them. I know all of these people. They would probably tell me to do what I want to do. But I would still ask them, do you want to have a different type of agreement? Which I would assume would be a different type of agreement, even if it's an HOA, I guess. I guess that would answer. There's still expenses that has to be paid for, and that would be under a different structure, not the HOA.
Commissioner Mitchell, do you have any further questions?
No, thank you for the testimony and your patience in answering my questions.
Commissioner Coleman has a question.
Thank you, Judge. I'm sorry, Mr. Blevins, if this is redundant. I had to step out for a moment and don't know if this came across, this was asked. However, in earlier testimony, you've noted you started with a litany of issues surrounding your wife's health and the drama and everything else that goes on with managing these various water systems. But I'm not, and then you've also talked about maybe getting out of the well water business altogether. I'm still slightly confused as to what your real intentions are, because now under Commissioner Mitchell's questions, you talked about staying on a line and managing that. If people want you to, you would share it with 5 others. So I'm not quite sure what I really like to know what your long-term plan is regarding the ownership and management of the different water systems that you've had and that you have. And again, excuse me if that was answered while I was out of the room.
I think I can answer that in a short period of time here. One of the things that I was asked to do when I took these wells over from different contractors is correct some of the problems that exist with these wells and existed 15 years ago. Maybe they weren't set up properly for descriptions, easements, or other distributions of the lines that were put in. Mainly talking about the easement. Some of the wells I have the deed to. Some of the wells I do not have the deed to because there is no description to make a deed from. It was a mistake made back 15, 20 years ago. I have corrected some of those, beginning from the count of 24 wells that there's the biggest number of wells that I've owned or had control of. Now, my long-term goal is actually a short-term goal, and that is to sell these wells. I do not want to be in the well business any longer, but I will not just turn my back on everything and walk away. I still have the fiduciary that I have to maintain with my original agreements. I've known these people for years. I've been partners with some of them, and I've worked with them. And it's always been an honest and truthful relationship and a loyal relationship. I intend to keep that. That's part of our relationship, let's say. I will keep one well for the reason that that's where I get my water from. That's the only one I want, or would keep. Not particularly that I want, but that's the only one that I would keep. But if someone else wanted to buy it, I would sell it to them, and I would pay them if they wanted me to pay them. But I don't want to operate a well system like the Public Service Commission is wanting me to do, like a utility. I don't want to do that, and I'm not able to do that, and that's the reasoning for my plans. Part of the reasoning, not the whole reasoning, but it's part of it. When I am here working on wells, or I have acquired these wells, and all of a sudden, and I've been working on these wells for 4 or 5 years, and even before that, as taking care of maintenance on some of them, for them, for the contractors. But when all of a sudden DNR says, it comes in and regroups things for me and says, you have 3 public water systems and we're going to activate you to that. They did that. They didn't ask me if I wanted to do that. They did that. That's evident. They didn't ask my permission. They didn't have to ask my permission, apparently. But I can't meet all of those requirements. I don't want to, I'm too old for it, you might say. And I can't do that work much anymore physically. I have to hire people to do that, the physical part of it. So when that accumulated with DNR, all of a sudden now I had some more stipulations coming in on me, which is from the Public Service Commission. There's 2 groups that are pointing sharp sticks at me, so to speak, and poking me. Sharp sticks. Those are requirements. I'm trying to meet every one I can, and able to. But I still have other things that are on the personal side that I can't meet either, which is physical labor. I can't do that. I have to take care of my wife. I have to take care of myself. And I have business connections that I still have to take care of, but I have to hire some of that to be done. So that's become I don't want to say a burden, because even though it is a burden, I will take care of it. I have taken care of my burdens all my life. And that's what's going to continue. That's my long term. My short term is to get that done as quickly as possible. And I have people assisting me in trying to get buyers for these wells. But I don't want to just sell them to anybody. I won't do that. It has to be to a person that has a need for that. The person that has a need for that are the people that are actually using the well. So one person in that group, like one well that's serving 7 people, one of those people should buy it, or maybe they should organize together and buy it. And I'm giving them that opportunity. The HOA is an opportunity that I can get away from in the long term, because I'm giving them the way to pay for it.
Okay, so the when DNR came in, there was some restructuring done, it sounds like, based on what you've just said.
Yes, ma'am.
So those that have been restructured, do you have the legitimate deeds on those? Because earlier there was testimony to there not being some deeds in place.
That's correct. Some of the properties, still, I have to get the deed from the grantors. But there's no problem in that happening either with the ones that are left. And one of those wells is the Rolling Hills well. I don't have the deed to it yet, but I could get that tomorrow.
So without deeds, you can't sell anything, correct?
That's correct.
Okay, so
not
there
myself.
So
but-
when you talk about, sir, that you're happy to sell these to an HOA or the appropriate person, when you have not moved forward with a clean title to a deed, it implies to me that maybe you really aren't.
Well, here's what the agreement is that when this deed is required, all I have to do is request for it. So what I would do is go to the grantor and say, take the information down to the title company and get the deed so that they can pass it on to me and my wife, and then we can pass it on to the new buyers, the new grantees.
Thank you, Judge.
Does that answer your question, though, ma'am?
Actually, I think we're going around in circles, so
I guess,
I'll end my questions there.
Yeah, well, I would just say that the deed would be provided
And
at
I
the
guess
time
that's-
that it's necessary.
Thank you.
I'm sorry to interrupt. I guess that may be what the commissioner's stuck on, and that's what I'm stuck on a little bit as well. If I buy something, like a house, I want the deed to it to show that I own it. And if somebody says, I'll give you the deed if you need it, and you don't need it now, that would probably talk me out of buying that house.
That's not what I'm saying, sir.
Okay, what are you saying? Are you saying that it would need to be separated from another property?
No,
Then why don't
I'm saying that the deed would be provided. I can get the deed tomorrow.
I guess the question is, why don't you have the deed when you bought the well?
Because I have a different document for it. It says that I have the responsibility of that. And these were some of the problems from the contractors, is that they had not made any descriptions for those wells. So if there is no description for example, the Rolling Hills well, then I would survey it, get the description, provide that to the grantor that would grant me that deed, or the description of that well to me in a deed form.
Okay, I think I understand. That makes sense to me. Are there any other commission questions at this time? Okay, I hear none. I've got a few for you, and then I'm going to go on a rather tedious run through the wells. So, to start with, let's talk about the 3 HOAs that you had indicated to me you were forming. Have you filed those with the Secretary of State?
Yes, sir.
And what names have you filed those under?
Charity. Yeah, I have the certificates here if you want to take a look at them.
I would love to take a look at them. Would you mind if we made a copy of those and made those an exhibit?
Sure.
That's fine, and I think those were also submitted with one of the monthly status reports that staff filed.
What is this exactly? Is this, because I heard lots of talk about how it couldn't be found on the Secretary of State's website.
Well, his businesses can't be found on the,
The businesses can, but the HOAs can?
yes. Yes.
Okay, I don't think that was clear at all. I think myself and the other commissioners got the impression that the HOAs were not findable on the Secretary of State's website.
I'm sorry, I thought I thought my questions were trying to make that clear, but,
And they may have, I may have just missed it. That's entirely
okay.
possible.
do you want to know which status report that was that I mean, I'm not sure what he has today, but,
Well, if those are attached to a status report, they're attached to a status report, but they're not in evidence. So I'd still like to have them in evidence.
okay,
Now, if you can point me to a status report, nobody objects, I can make those an exhibit
okay,
without anybody having to copy anything.
that'd be great.
Mr. Blevins, hold on. I think if it's already in existence electronically in our records, I'd just like to make it an exhibit, if there's no objection from either of the parties.
I have no objection.
It looks like it was the March status report that was filed in WO 2024-0036. And that was filed March 7th of '24.
I will call that Exhibit 22, and I will call that a commission exhibit.
And again, I don't know if Mr. Blevins has something different, but that's what we found, was just the fact that there are HOAs registered.
I think that's all that we wanted to know.
Okay.
Mr. Blevins, do you have any objection to admitting the attachments that are Secretary of State HOA filings for you from the staff's March status report?
I don't know what it looks like.
If you want to
Yeah.
show it to him?
Sure.
And just the attachments, not the status report.
That's the one that we found for charity. This is the one we found for Rolling Hills.
Well, yeah, that's,
Is that what you thought? That's what I'm asking, that's what's gonna be entered into.
Mr. Blevins, are those are those copies of your Secretary of State filings for the HOAs?
yes, sir. That's the Articles of Incorporation and the,
To the best of your knowledge, do they look correct?
well, that'd be the same thing I'm pulling out here for you to copy. What you don't have, I guess, there's the articles and there's the certificate. I guess y'all got all three of these, right?
Yeah.
That came from the state. so-
Okay, and those look identical to the filings you made, correct?
Yes, and the only thing you probably don't have are the bylaws and the declaration.
Okay, but outside of that,
If you want copies of those, I have these here.
no, I don't believe that's necessary.
Okay,
Do you have any objection to the commission making an exhibit of those
no
attached to the
objection.
status report?
You still want a copy of the, here?
No, not if we've got one.
You already have them.
Any objection from the commission staff? Okay, Commission Exhibit 22, the Secretary of State HOA filings is admitted onto the hearing record.
Okay, do you need copies?
I can make those.
Okay,
Thank you.
sure.
Okay, Mr. Blevins, I want to briefly, just because the ownerships of the wells has been such an issue in this case, I kind of want to just go through briefly, as quickly as I can, through each one, and I want to kind of cover three things, which is, what it is, who owns it now, and why it is, or how it is you came to acquire it. So, well, let's start with MW01, which is Tigger number 1, I believe. And that had 10 connections, currently has 9 connections. And my understanding is that the Tigger HOA has taken that over.
That's correct.
Okay. Now, MW02 is the Tricia well, and that has 4 connections, correct?
Well, the MW02 has been sold some time back.
I understand, but it has 4 connections?
It has one. Oh. MW02, I believe, is 3 or 4 at the most. I don't recall.
All right, well, let's not go over a number of connections now then. You said that was sold. Do you, when was that sold?
A few months ago.
Okay.
I don't know exact date. I'd have to look it up.
And who was that sold to?
It was sold to one of the occupants there that wanted the well and the property that it was on.
So it was sold to a property owner.
Yes, it was sold to a property owner that's on the well. Jack was his first name. I'd have to look it up for the proper name.
MW03 is the Taylor well.
That's correct.
And who owns that now?
I own it now. I got that deed on 2nd of February, just in the mail with no expectation of it from the person that I sold it to.
Okay, and I remember your explanation that.
Yeah. But there's a kind of a legal question there too, because I didn't have to accept that deed. But
Yeah, I'm not going into that right now. My understanding, if I remember correctly from you, is you sold it for $12,000. You put $12,000 back into fixing the well,
yeah,
essentially gave it to them, and they've mailed you the deed, and there's been no communication between you and that party. So
that's correct.
you don't know if they're asking for $12,000
Or what?
or what.
Yeah.
All right,
So,
let's go on to MW04, which
Yeah.
is Tigger number 2.
that's correct.
And that's the one you're currently hooked to.
That's correct.
And who owns that?
That is there is no legal description for that particular well.
How did you acquire it?
Well, I acquired it from the contractor. Can I give you the name, or do you want the name? He's the grantor.
Hold on a second. I'm thinking for just a second. How was it sold to you? Was it a handshake deal? Is there a contract? Is there anything written?
I think it's in one of those exhibits there where purchase of a well, and that would be on Tigger, and it was the one that shows responsibility and transfer.
And so that's on one of the tax documents, correct?
I don't know what document that was put on there. Maybe it was. I'm not positive.
Okay.
But that was acquired in a written document, and that was a problem project there to get the deed or the description of that particular well finalized, basically. So it's going to require a survey of sorts, or it can just stay like it is, as far as I'm concerned.
I
But
understand. If you're not selling it, yeah, it's
we're not selling it,
Okay.
no. So there's no.
MW05 is the topo well. It is collapsed, and you have no idea who owns that, correct?
Well, I do have an idea of who owns it, which is one of the neighbors. It's on their property, very similar to Well, I've been told that there is a description for that particular well, but I haven't seen it. And I'm going to have to ask for that description so I can find out who actually owns it by the courthouse.
Okay. And MW06 is one I am not familiar with. That is the Rustler well.
The what?
Rustler well, I believe they're calling it.
No, that's not Rustler. MW06, I think, would probably be the one that's they testified to be on Rejoice.
What's Rejoice?
Pardon?
What is Rejoice?
It's just a roadway where there is a well up there. It's a 3-horse well. It was owned by another party. Okay. It has, I don't know, 4 connections, maybe 4 or 5 connections.
The MW06 has 4 or 5 connections?
I think so. I'd have to research on it. That was, I think, in the original transfer. Was that in the transfer on that one exhibit, Ms. Kerr?
I don't think they know which particular wells are on that particular.
Well, it'd be, Rejoice would be the address. It showed each address that was transferred.
There, let me get to that.
Is this in the tax documents?
I believe that was from the recorder's office.
Okay, so that's in with the deeds.
Yes, I think what he's referring to is the first document in Exhibit 17, which is called the Well Transfer Agreement.
Yeah.
And it lists,
A number of wells, if I
it
remember
lists a
correctly.
number of wells, and it does have Rejoice Road on it, but there's nothing in there that says which well it is, or describes the well that,
Okay, who owns MW06?
LD Property Management does. At the present time, that's only been a recent transaction.
You sold it to him?
No, the other person sold it to LD Property Management. I
And,
do own part of LD Property Management. And the control of it and pay for it, the water, goes to Home, HOME, which is another company that the grantor at that time,
And that would be Home LLC?
LLC, is correct.
Which-
That's the, I think they listed that on there as the person that, or the entity that was transferring, right, on that
Now-
document?
Now, Home is the owner of, Home LLC is the owner of MW07, is that correct?
Yes, MW07 is the Rustler location, and that is described, but I'll be asking for that deed probably when I get to it.
So you believe you own that?
I do, I own it.
How-
I don't have the deed to it, but I own it by virtue of these other transfers that have taken place. And I either own it or manage it or have possession of it.
Okay, so this was a contractor transfer to you?
Yes, it was, and in the beginning, yes.
Okay. Now, I don't see on my list an MW08, but I heard you mention an MW08.
MW08 was a well that was also up on Rolling Hills. And I sold that sometime back, a couple of years ago, maybe a year and a half or 2 years or whatever.
Who owns that?
That is owned by one of the residents up there that the well is on.
Okay, so a property owner.
Property owner, yes. And they service, see, 1, 2, 3, 4 homes, I think.
Okay, MW09 is, well, it's labeled here as Carthage.
Carthage is, that it's not part of the public water system, that's part of that seven.
No, I'm
that's
just going through all of the wells. I
Yeah.
just want to kind of be able to figure out who owns all of them.
That is, that description, I don't know if I've got I don't think I have the deed yet, but there is a deed for it.
Do you own that?
I own it by virtue of either the transfer or a deed. I think it's a transfer, and all I have to do is ask for the deed, and it would be made.
Would it be owned by Nicholas Perez?
No, he's the user, consumer. He's the property owner, but not the well.
Okay, is there an MW10?
There is, I'm trying to remember. It's not, MW10 is an older well. It's not a current,
Not current?
not a current reminder in my mind here.
Would that be true of MW11 as well?
And 10 and 11 would be also on Carthage, and they've been sold, both of them, to the property owners. Actually, one property owner, I think, owned both of them.
MW12.
12 is on Chicago Road that was sold, property owner.
MW13,
Let's see.
and I have that listed as the Corvair.
Corvair, yes. I still own them part of the 7. Well, it's on a contract sold to that other individual.
So that's sold to a property owner as well?
Yeah, no, not property owners. That was sold to that lady I told you about that has the other 7 wells that I help manage with her.
Okay, and what's her name?
Amanda. I've got those documents that,
No, I don't need to see the documents. I'm just trying to square who owns what. And
Okay.
Amanda what? Does she have a last name?
pardon? Amanda Rector, or the last name.
Okay, MW15 is charity number 1. Well, actually, I skipped 14. Is there an MW14?
NW14 was a sale a long time ago, and it was not a well house. It was just a hole in the ground. It was drilled but never put in. But that was one that DNR had some issues about, and I don't know what really happened with that. That was a different owner altogether.
Okay, so is that owned by a property owner now?
That's owned by the property owner, yeah. Yes, sir.
Thank you. MW15 is charity number 1.
Charity number, yeah, that was the one that was sold. That's the property owner owns it.
Bear with me just a second. For simplicity, why don't you tell me the 7 wells that are now owned by Amanda and managed by you?
That would be,
And you can just refer to them by their MW number.
MW09.
Okay.
MW 19 and 20? Oh, MW 19, 20. 19 and 20.
Okay. All right, any others?
MW 21, MW 22, MW 23, and MW 24, owned by Amanda Rector.
So those are all, that's 19 through 24. As well as 13 and 9.
9 currently, 13 originally, but it has been sold. 13 has been sold.
I was talking about the ones that, you manage that Amanda owns.
Yes, that's
So-
correct.
So that's 9, 13, and 19 through 24.
That's correct.
So she owns 8, correct?
She originally owned 8, but number 13 was sold, so the balance is 7.
Okay, so 13 was sold to somebody else?
Yes, to the new property owner.
Okay,
When they bought that house from the original property owner, she wanted to buy the well with it, and took out 3 other homes with that, I think it was.
okay, and that leaves 3 unaccounted for at this time, and that's 16, 17, and 18, which I believe are all charity wells, is that correct?
That's correct. 16, 17, and 18?
Yes, who owns those?
Who owns them? I own 17. I have the deed to it. I believe I have the deed to MW 18. I still have to get the deed to the concrete well, which is the MW 16. I think it's 16.
16, what's that one called? When you say concrete well, that's not the Taylor well, correct?
No, it's not the
Okay.
Taylor well. That's the one on PP Highway.
But you believe you own that one?
Yeah. Oh, yeah. That's the one that the DNR wants me to, that originally wanted me to plug, that I put the new box in, the control box, to repair it.
Okay, second round of questions. Which ones do you have deeds for?
I own,
I'll just go through. Do you have a deed for MW03?
yes, that's Taylor.
Okay. Do you have a deed for MW04?
No, that is still an easement in the records.
Do you have a deed for MW16?
No, that is still in, probably be in Home LLC. And I can get the deed to it, supposedly. All I gotta do is ask for it.
Is that true of MW17 and 18 as well?
17, I have the deed. 18, I have the deed.
Okay, so just to go over what you believe you own. MW03, because you received the deed in the mail, but you may or may not accept that.
Well, I've already accepted it by continuing to repair it and put it back in operation.
MW04,
I don't have MW04 is the one on Tigger, which is still an easement.
yeah, but you believe you own that as well, correct?
Oh, yeah. I
So you
it.
own, I'm just going over the ones you own. You own MW03, MW04, MW16, MW17, and MW18?
Yes.
Is that it?
No, well,
That's 5 by my count.
well,
And we've gone over the ownership of the others. So is 5 correct?
Oh, let me double check. Well, I own 7. I have control of 7.
Okay, I have that listed as owned by Home LLC. You own it, but they have the deed. Is that correct?
They have the deed, but that's also in that transfer. If I don't have the deed, it's in a transfer.
Okay, would that be true of MW 06 as well? Or is
No.
that, you said that it, LD Property Management?
That's correct. That's a new transaction.
Okay.
It was done probably, I think, I don't know, maybe 3 months ago, 2 months ago, maybe.
Okay, let's go over briefly this transaction with Amanda that took all of these wells off of your hand. Did you transfer deeds with any of those to Amanda?
No, absolutely not. Not at the present time. I took a down payment and a contract for deed with a note for payment.
And you indicated that there's a clause in there that allows you to sell it to somebody else.
What clause? That
Well, you indicated that there was something in your arrangement with Amanda that you could sell the well to somebody else. Is that correct?
oh yes, yes. The agreement there is that I'm trying to help her pay for some things that she needs to pay for, so I sold her these wells on what I call a fire sale. I don't know what you may interpret a fire sale to be, but it's sold for less than.
I'm aware of what a fire sale is.
Okay, so I sold those wells to her for $6,000 each. Okay, they with an agreement that I would help her sell them to different property owners so that it gets in the right hands, and she would be sold for more than the $6,000. So
Well, doesn't that just sort of take them out of your hands?
not really.
But I mean, because you're
That-
you're technically, according to you and contract, you don't own them, but you still manage all those wells, correct?
I help her do that, yes.
Now, I want to talk briefly about your arrangement with the contractors that gave you these wells or transferred these wells to you. Did you buy these wells from these contractors?
Yes, sir.
Was it a payment over time agreement? I mean, are you still remitting payments
No.
to these developers?
No, to the developers, they're all paid off.
Then what is this fiduciary duty that you're talking about?
Well, fiduciary is what the original agreement was, that responsibility for to get the wells, and that's the agreement, in the right hands if there's a problem with them. And there are problems with these wells. Obviously, there was problems with the legal descriptions on some of them, and still is. A couple of them need to be surveyed. But the fiduciary is that it would go to not just to anybody for whatever purpose, that they would go to an HOA. That was some of the verbiage that was used. And I don't know if it's written in there or if it was just verbiage, but I recall that to be true, especially with one of the contractors.
Okay. Let's see, I thought I had. Okay, those are all my questions. That went much faster than I thought it would. Any recross from staff based upon commission or bench questions?
Yes, I just wanted to clarify something. The wells that the judge listed that you don't own, or that you say that you don't own, are you still charging those customers for the use of the water?
Let me clear up how I understand your question and what verbiage you're using by don't own. I own all of these wells in some fashion or manner, either by that that document that you presented there, showing the transfer of the responsibility for them, and etc. I own them. The problem existing with the ones that I own by deed, there is no problem with them. I've got the deed already, but some of them I don't have the deed to.
Okay,
but
but you just testified that you didn't own a number of wells that the judge just listed off.
Which wells are we talking about then?
Like Rejoice, MW 08, 11, 12, 13, 15, and I guess the ones that were,
I think they're mixed up there from the public water system ones and the other 8 original wells that went to Amanda Rector.
I guess my understanding, if I'm wrong, of counsel's question is, are you still billing and receiving payments for water from the wells that are now owned by Amanda?
Yes, we do, but it's credited to Amanda. She uses our office for the collection of those funds. We do. We still manage with her.
and I guess I was asking about some of those other wells that you said you don't own, that you just testified to that you don't own, like the Rejoice system, MW 08, MW 11, 12, 13, and 15. You said you didn't own those, but you still service them and you still charge those customers?
I guess I don't follow your question because some of those have been sold.
Right, the ones that you say have been sold.
No,
You
we don't collect any money on them, except for the one with Amanda. We
Okay.
collect those in through our accounting system that we use here in the office.
Okay, I just want, and so the Rejoice system, do you still service them?
Rejoice, that's a new one. Yes,
Okay,
we
you-
service them, but we first service them through Home LLC.
Do you
We don't
charge-
collect the money there. The money goes directly to Home LLC. Home LLC later distributes the funds by our further other agreements. We don't handle the money there.
Okay.
But I do go, if there's a problem, I go and fix the problem
Oh, okay, I just,
for Home LLC and the LD Property Management.
okay, thank you.
That, I don't know how else to explain that.
And the deeds, you said you have those deeds some of those deeds have not been recorded with the recorder's office?
All of the deeds that I have been recorded because that's where I get the deed from. They've been recorded, the ones that I do have. I don't have any that's not yet recorded, other than the ones that I don't have the actual deed made up for.
And those are the ones that you say you own? But you just don't have the deeds in your hand?
Yes, I own all of the wells by either that document that transferred that ownership to me or responsibility to me or the deed. That's how I own all of the wells.
What document transferred responsibility to you?
That was in one of those exhibits there.
Okay, so that's the sale of wells agreement?
I
Yeah.
believe that's the well transfer
Yeah,
agreement?
that's what
Right.
I'm talking about.
Yeah,
Yes,
That lists a whole bunch, it's broken by section, and then
Yes.
yes,
and
okay.
it's got the address of those.
So that is the document that you say originally transferred ownership to you
Yes,
from the contractors, and I believe it's Baker and
Don
Parsons?
Baker, since you mentioned the name, yes, sir, it's Don Baker. That's correct.
Okay.
Okay.
And I could pick up the phone and tell Don that I need the deed to whatever, and I'd tell him why, and he would have it done. He'd go down to the title company and have it made. That's our agreement. I've dealt with him for many years.
Okay. I think that sort of answers my question.
Mr. Blevins, normally there's something called redirect. It's essentially an opportunity for you to tell the commission anything finally that you wanted to tell the commission before I end the hearing.
I don't know. There's probably a lot I could tell you, but I think maybe to close it up from my viewpoint, is that I would just ask the commission to look at what the real purpose of me operating these wells and what I want to do with them, and look at maybe the difficulties in trying to meet all of the Department of Natural Resources requirements and the Public Service Commission. Personally, I don't know what the Public Service Commission is really after. I don't know what that is, other than what they testify to. If they want to, well, I don't know what to tell them. The Department of Natural Resources has been the one that has helped me in the past with these wells, especially in the condition that that we've evolved to from all of these transactions that have taken place. It was never intended for these wells to be any type of a public water system. This was created by one of the Department of Natural Resources employees. That's where that was created. I didn't create that. And I certainly didn't know about the Public Services Commission until they walked in my door. I still really don't know what they keep wanting from me. I've provided what I could. I've taken steps to not have to be under that particular guideline or whatever it is, legally, not legally, but honestly. I mean, I can't meet what they want. Do they want me to, I don't know. So it's my goal is to not have to deal with any CCN requirements, because I can't do it. Neither can the consumers for these wells. There's no other water available to them. I'm their only source at the present time. I'm not going to let them down. I'm going to try to finish up what I'm supposed to finish up from the time that I started this with the contractors that I took these wells over and what I've done since then. I've spent a lot of money, which that's water under the bridge. It's already gone. I've got money to go ahead and spend again, more, because there are other requirements that's not met yet. So I'm going to have to meet them some way or another. It may not be on their timeline, and maybe I'll be put in a different category. I don't know. I don't know what's going to happen, but I can't continue to be not informed or what to expect from the Public Service Commission, for example. I still really don't know what to expect from there. DNR, pretty well, I can expect what they've already written to me. I don't know what to expect if I can't meet their requirements, and I guess there's been a a testimony that tomorrow I'll be referred to the Attorney General, is that right? Is that one of the statements, I think?
I
Mr.
believe, yeah,
Stamp made?
that was my understanding from Witness Johnson.
Okay, well, I didn't know it'd be tomorrow. I heard that today.
Well, that is
Or
new to me.
yesterday,
That is
may-
new to me, but my understanding was that from Witness Johnson was that today was a DNR deadline for certain actions.
Yeah, there is a deadline there today, yes, correct, and I think that is the plugging of well on topo,
Okay.
I believe. That's one that I know of. That can't happen because there's still a problem there. DNR's not aware of the problem. As far as I know, they haven't been told that we don't know who yet, really, but I'll find out. I'm going to find out. I just haven't had time. Again, time frames are pretty important, apparently, to the Department of Natural Resources and the Public Service Commission, but those time frames don't fit very well in my world. I tried my best, but some of them I just can't do.
I understand. Thank you for your testimony, Mr. Blevins. You can step down and I'll end the hearing. What I will say is at some point an order will go up before the commission, and the commission has usually an agenda meeting once a week. Occasionally around holidays, an agenda may be bumped or skipped, but usually once a week. There's an agenda meeting whereby the commission discusses and renders their decisions on various actions that are pending before the commission. And if at some point your case will be up for consideration at an agenda, and if you were to listen to that agenda, you might hear some discussion about your case, as well as have an idea of what an order is going to say. Okay? All right.
How do I get in touch with the agenda?
Well, that gets to be a little more difficult because I can't really walk you through all of the internet things that are involved. But basically, it's available to watch online on YouTube usually. Is that correct, Brian? Yeah, on YouTube. Yeah. So if you go to YouTube, it's also, if you go to our website on the home page, you'll find a link to agenda. And when agenda is live, that link is clickable.
Okay.
Is there anything else I need to address before this hearing is adjourned?
Did you want staff to do a brief?
Does staff want to do a brief?
We'd prefer to do, yes.
Okay. How long would staff like to have to do a brief? Today's June.
I guess once the transcript's available, then
Let's go off the record for 2 seconds. Okay, staff has requested to do a brief. We discussed off the record what the availability of the transcript and the briefing schedule. And so any briefs by staff will be due on the 23rd. Mr. Blevins, if there's anything that you want to write about this, a brief is usually kind of like a closing argument. It's very similar to an opening argument. It's not actually evidence, but it frames for the commission how they may want to look at certain issues from the perspective of the parties. If you, and I'm not requiring you to write a brief. You do not have to do one if you don't want to, but staff has asked to do one. If you do wish to write essentially an argument on your own behalf beyond what you've done today, you would need to submit that by July 23rd for this complaint case. Okay?
Great.
All right. Is there anything else before I adjourn?
Do you want to, I think all the exhibits that were offered have been marked and received.
I have 22 exhibits, all of which were marked and taken into evidence, 5 of which are confidential.
Okay, that's what I have as well.
All right?
Yes, I think that's it, then, yes.
Yeah, I've got 21 issues from the party. 20 of those are from the commission staff. 1 of those is from Mr. Blevins, and 1 is a commission issue, or is a commission exhibit.
Yes.
And if you want, I'll be happy to list through them. But if we're going to do that, I'd as soon go off the record for that.
No, I think we're fine.
Okay. All right. Hearing nothing else before the commission today, I will adjourn this hearing. Thank you all for your participation.
Thank you.
Thank you, Judge.
Thank you, Commissioner Kolkemeyer.